lost Commissioner Jones.
What's that?
We lost Commissioner Jones.
We did.
Okay, I think we're ready to call the meeting of the Colorado Independent Ethics Commission to order on October 13th, 2016. This is a special meeting that we've called to consider a single issue, I think, which is the draft position statement concerning home rule cities and counties. Let's take the roll call. Commissioner Smith.
Here.
Commissioner Jones.
Here.
Commissioner Bacon.
Here.
And we welcome new Commissioner Joanne Sorensen.
Here.
Okay. Commissioner Sorensen, you want to introduce yourself to the other commissioners and to the public?
Okay. I'm Joanne Sorensen from Clear Creek County. I have been an elected official. I worked as a county commissioner for 8 years there, and after some time off, came back to work for the county in land use and currently in transportation. I've served on nonprofit boards in the county and in the region, and I've served on other governmental agency boards like our library district, our fire authority district, and have been an engaged community member for decades.
Thank you. Well, welcome to the commission, and thank you for your service.
Thank
you. Obviously, our commission is kind of a unique animal. It's not quite a legislature, it's not quite a court, and it's not quite an administrative agency. It's a constitutionally created board, and so everybody has a chance to speak their mind. So if you have anything on your mind, you just yell at me. Okay? All right. So let me set the stage for what we're doing here today, and we'll see if we can't get our business done as efficiently as we can this morning. For some time now, the Commission has been considering the question of its jurisdiction and the reach of the constitutional amendment vis-a-vis home rule cities and home rule counties. The issue was brought into focus primarily through a series of complaints and requests for advisory opinions in which public officials asked questions. I think probably the clearest example of that was a request for an advisory opinion by a City of Aurora, a city councilwoman who also happened to be a state employee, and her question was, am I governed by the state ethics code or am I governed by the Aurora ethics code? And that caused us to ask the question, why should there be a significant difference, and led to a discussion of some of the differences between the Aurora code and our own state code. In particular, I think the fact pattern that brought the issue into focus was whether or not it would be considered an ethical violation for real estate developers to pay for trips by local officials to various places to see developments. And we had recently dealt with that issue on this commission for a non-home rule city official, and had determined that it was inappropriate under the state constitution for real estate developers to essentially take elected officials on trips to, in that particular case, I think it was to a horse racing ranch in Florida as part of their discussions with the elected officials about their development. But we learned that not all cities view ethics in that same way as we did, and that that would be an example of a potential conflict. Since then, we've had a couple of other cases that have also brought that same issue into focus, where at least one other city seems to have taken the position that it's okay for people with business before the city council to pay for trips and entertainment for members of the city council to go to locations and talk about city business. In addition, we have a series of other cases that are backed up on our docket right now that are still, I think, in the confidential mode because they're complaints that have been filed that squarely raise the issue where a complaint has been brought in a city and either the process of investigating and adjudicating the complaint has been alleged to be inadequate and non-compliant with the state constitution, or the result of the deliberation has been a decision that would appear, at least on its face, to be squarely in conflict with the state constitution. And but we've had people assert that notwithstanding that these behaviors and issues are squarely in conflict with the state constitution, that they're permitted because they occur within the confines of a home rule city or county, and home rule cities and counties can make their own rules as far as ethics are concerned. That, I think, sort of frames the issue. So we've had a series of hearings, a series of arguments. We've received submissions from a number of home rule cities and home rule counties. I don't remember now how many hearings we've had on this, but we've had public discussion and discussion among the commissioners on, gosh, at least 4 or 5 occasions as I count, not counting the specific the discussions that have taken place in the context of specific matters. And so as a result of all that deliberation, we have a draft position statement that was prepared by our executive director to reflect what seemed to be the consensus of the then commission. We have a draft dissent from Commissioner Jones to that position statement, and we had a request at one hearing, several hearings ago, from Ethics Watch that perhaps we might want to consider deferring taking final action on the home rule city issue until we had our 5th commissioner, who it just so happened in this particular cycle that 5th commissioner was to be a member of state or local government. And so we've made efforts to fill that 5th commissioner position, and that's what brings Commissioner Sorensen to us. So we are now, once again, a full commission of 5. It includes our representative of local government, And the purpose of this hearing today is to review, hopefully for one final time, our draft position statement and the draft dissent, and a potential, I guess I'll call it concurring opinion from Commissioner Smith, concurring with I think the general outcome, but suggesting some modifications. And so I think we're going to be poised today to consider those potential modifications to see if we want to modify our draft position statement. I think probably, and this is as much for Commissioner Sorensen's benefit and for those in the public maybe who have not been at one of these hearings before, let me go a little bit farther to kind of frame the issue as we see it, or as we have discussed it, or as it's presented to us by the Constitution. Amendment 41 contains a provision that I think it'd probably be fair to say in our discussions we've been forced to interpret. I won't say whether it's ambiguous or not, because there's no reason to provoke that. There may or may not be agreement about that, but it certainly has required us to engage in some interpretation. And the provision says that any county or municipality may adopt ordinances or charter provisions with respect to ethics matters that are more stringent than any of the provisions contained in this article. That's the first clause of the amendment. The second clause says the requirements of this article shall not apply to home rule counties or home rule municipalities that have adopted charters, ordinances, or resolutions that address the matters covered by this article. So our effort here has been to attempt to resolve the tension between these two clauses. In the one clause, it seems very clear that the voters intended that the state constitution would set a floor, but not a ceiling to ethical provisions for all counties and all municipalities. In the second clause, something has been done in the amendment to give home rule counties and home rule municipalities some control over their ethics provisions. The only guidance being that these home rule charters and ordinances have to address the matters covered by this article. There are different ways to read that provision, and Commissioner Jones' dissent, I think, takes the position that if we simply apply the substantive provisions of the amendment to home rule cities and counties, what is left for home rule counties and cities to adopt. So, for example, the amendment places a limit on gifts to elected officials of $59. What if a home rule city and county were to adopt a limit of $75? That doesn't seem to necessarily offend the spirit of the Constitution, but what if the home rule city or county adopts a gift ban of $25,000? That would seem to be utterly at odds with the spirit of the amendment and would place beyond the reach of the state constitution all elected officials and employees of all home rules and municipalities. And some of us have struggled with the idea that the voters intended that. On the other hand, the amendment contains some provisions that seem more elective, if you will, not as prescriptive. So, for example, the number of people that might be on a home rule city and county ethics board may or may not be prescribed by the constitutional amendment. The political composition of a home rule city and county board may not be prescribed by the Constitution. Whether the home rule city has a separate prosecuting office or a integrated prosecuting office may or may not be governed by the amendment. So the question for our commission has been, so far at least, to try to define what parts of the amendment are really the heart of the amendment and should be treated as applicable to all counties and municipalities such that any effort to deviate from those provisions would be considered as a home rule in city or county adopting an ethics code that does not, quote, address the matters covered by the article in any realistic or substantive way, and to separate those from those provisions of the amendment that are less prescriptive and that give home rule counties and municipalities some flexibility in determining how to approach their ethics codes. And again, I think the operative words here are the Constitution seems to require that home rule municipalities and counties address the matters covered by the article, and therein lies the rub, I think, is for us to determine whether or not a home rule city that has a ethics provision that is directly contrary to the provisions of the statute or the Constitution has really fairly, in the words of the Constitution, addressed the matter. So hopefully that helps frame the issue for our consideration today. So I'm going to assume some familiarity with the draft position statement. It's been on the website for a very long time. Given that framework, I can summarize, I think, what the draft position statement says, and then we can move to the, I think, individual commissioners' comments on the draft. But in order to try and reconcile these competing interests that I've just described, the draft position statement specifies that home rule cities and counties can adopt their own ethics system, code of ethics, and system for enforcing that code of ethics, as long as it addresses certain core provisions. One core provision is that it has to include a gift ban, and that gift ban needs to be consistent with the gift ban prescribed by the state constitution. A second is that the home rule city and county ethics code has to contain a prohibition on covered individuals from receiving money, forgiveness of debt, et cetera, without providing consideration equal to the value of whatever was received. A third is that there needs to be a complete ban on receiving gifts from lobbyists. The fourth is that the code must include a restriction on representation after leaving office. A fifth is that there has to be an independent commission comprised of members of different political parties with provisions that govern the manner of appointment, manner of succession, et cetera. In other words, there has to be an independent commission, and it has to have investigative and enforcement powers and allow penalties to be imposed. I don't think the draft opinion specifies what that has to look like, but it does require that. We've learned that some cities and counties have, instead of having an independent ethics commission, have the city council or the board of county commissioners act as their own ethics commission for their own ethics violations. I don't think I'm going too far out on a line to say that the commission would regard that as not compliant. I think we've already addressed that in the context of state government, where we've said that, for example, I think we have an opinion out there that the state legislature can't be its own judge of its own ethics. The sixth provision that we've identified as being required of home rule cities and counties is to have a process for covered individuals to seek ethical guidance. I don't think our opinion specifies the method of that, but that there has to be some sort of a process by which you can ask permission. And then the last would be that the commissions in the home rule cities and counties need to have jurisdiction over ethical issues that arise under any other applicable standard of conduct or reporting requirement as provided by law. This is a little, I think what we're getting at with that, and if I can explain that, and maybe one of the other commissioners has a different view of it, but this commission has struggled from its inception with the issue of whether or not the state legislature can define standards of conduct that the commission needs to apply. And so, for example, there was an effort early in the commission's existence for the state legislature to adopt a piece of legislation that basically said, instead of having a dollar limit on a gift band, we should just prohibit gifts which, essentially are a quid pro quo for some official action. I'm summarizing the statute now, but the idea was that that really the intent of the statute was to avoid conflicts of interest that might influence someone's vote or decision, and that therefore, if you had a state piece of legislation that said that's an ethical violation, then you didn't have to deal with the dollar amount of the gift band. The commission took the position that that was an interesting piece of legislation, but it was inconsistent with the Constitution, because the Constitution, in order to avoid arguments in every case about whether or not a particular gift, could influence or corrupt a public official, the state constitution took the position that a specific dollar amount of a gift ban should be implemented to as a kind of a prophylactic measure to prevent undue influence on a public official. And so the commission took the position that it was an interesting piece of legislation, but that we're not bound by it. I think that position has been borne out now by the state Supreme Court, that as a constitutionally created commission, we are not subject to that kind of legislation. Our obligation is to enforce the Constitution, irrespective of what the legislature might want to adopt with respect to limitations. So I guess that frames another issue that we have to discuss today, which is, I think, to kind of state the issue differently, having already taken the position that the Constitution is sort of the supreme ethics code of the state, so much so that the state legislature lacks the authority to modify its provisions, how is it that home rule cities and counties would have a greater authority than the legislature to exempt themselves from these core provisions? So with that table set, why don't I start? Commissioner Sorensen, you're the newest to the commission, and so I guess I probably want to make sure that you're up to speed sort of with us before we start our discussion. I don't want you to feel left out. And so let me start with asking if you have any questions for us before we, or do you want to just kind of follow along and chime in when you're ready?
Could I follow along? I did have some questions, but I'm not sure how they fit into the exact conversation at the moment.
Okay.
So.
All right. Commissioner Bacon, do you have any comments that you'd like to start out with this morning?
This has been one of the most confusing issues, and it's been difficult for me to try to address these issues or address the matters, and what sort of robust addressing of the issues ought to be required. And it appears to me that early on I was saying I would like some sort of court in order to make some sort of decision, rather than our just rummaging around through this for a long period of time, trying to determine for ourselves what the significant addressing of the matter might be. We've had some cases coming before us, and it seems perfectly obvious to me that the policy, whatever the city council has adopted, really don't pass a smell test, that they are robust enough in order to deal with it. And I'm particularly disturbed that there is not an independent, sometimes ability to investigate and hear them, and then when certain ones then throw it to the city council or the county board of commissioners, and they may be the object of whatever the complaint is, it appears as though it is working around the intent, I think, of Article 29 of the Constitution. And so I really would like someone, somewhere, in order to let us agree on what it is that needs to be done, in taking on cases when these cases are brought before us, and it's somewhat obvious to us that the statement, the article, whatever it is that the council or the commissioners have done, really does not address the matter of the ethics. And I'm willing to make a statement so that eventually some court somewhere could make that determination, because what we're doing is second guessing again and again, and have to admit that there are good people on both sides who have really considered opinion of what it is, but we're both talking past each other. And I really would like some sort of definitive way in order for a determination to be made on whether or not these ethics codes promulgated by county commissions and city councils really do address the matters of Article 29, even though it does say that if they have them, they are exempt from our authority. So it's a murky area for me, and I'm at sixes and sevens in trying to deal with what it is that the commission ought to be doing, and I really think ultimately a court decision needs to solve this.
Commissioner Jones, you are the author of a draft dissent. Would you like to present to us and for the arguments for the dissent?
The murkiness of the sentence of the Constitution is the problem. But the conclusion that I have a problem with is when we say that the home rule cities must have a gift ban of $59, for example. If it was the intent. So the second sentence of Article 29, Section 7 specifically states the requirement of this article shall not apply to home rule counties or municipalities that have adopted charters, ordinances, or other resolutions that address the matters covered by this article. And to go and then say, in order to be able to resolve this issue without having to look at it on a case-by-case basis, let's make the gift ban $59. It's clear, it's a bright line, it's easy. I don't believe that was the intent of the amendment. I mean, there's no reason to have the sentence that gives the home rule cities an option to not have the article applied. You just leave that out, and then you could just apply it carte blanche, and there'd be a bright line test that applied to everybody. I don't see that the way the draft position statement is so specifically applies parts of Article 29 to home rule municipalities without exception. I don't see that as honoring the voters' intent. And so that's my problem with it. I completely agree with the chair's comment that a $75 gift ban or a gift limit might be fine, and a $25,000 one would not. I don't think a $25,000 gift limit is consistent with the intent of the voters, but I don't think we should say $59 and then therefore make all $75 limits and make them to be a violation. So that's the problem I have with the position statement as written. I believe there needs to be more finesse and more room to allow home municipalities to have their individuality that was contemplated, but at the same time not allow them to go so far afield that it flies in the face of the constitutional amendment. I think the trick is figuring out what that is and how broad, what language we need in order to allow the individuality without without the ethical violations that we all, I think, I mean, there are obviously some limits and criteria that go so far afield that we would all say that it's a violation. And when I say we would all say, I mean, we'd all say $1 million was a violation. There are limits that can be put in place, that need to be put in place, that aren't in the draft as written.
Sorry, I didn't mean to cough.
Yes, you did.
Is there any water around here, Kyle?
You know that.
Those Court of Appeal judges are tough, they don't need water.
I'll tell you a story one day about when I was clerking for the Court of Appeals, and some poor clerk forgot to change the water in the pitchers, and they get moldy water in the lining around the liner and poured that into the judge's water, and they got sick. But anyway, go ahead. Commissioner Smith.
One other point that I would add. Now, I do agree that there are parts of the language that are less significant than others, and that we should ferret out the absolutes from the variables. But again, that's part of what our job is here today.
Thank you, Mr. Chairman, and Commissioners, I have some comments in front of you. Before I get to the comments, to reiterate the opening that the chair offered, is we have been working on this for some time. And I want to thank the chair. We have tried to reach out and gain input from those affected, the home rule cities and counties, which didn't happen right off the bat, just to record that. But ever since the draft position statement has been made available, we've received a lot of input. And I want to thank not only the home rule cities and counties for participating and offering their comments, but I also want to thank some of the entities that represent all of Colorado's cities and counties. I think we are finally at a point, Mr. Chairman, with your diligence of really having a comprehensive slate of information in front of us so that we can now move forward. I've been somewhat impatient as a commissioner and chomping at the bit since July to tell everybody what I thought Article 29 meant. The chair has asked me to hold that, but at the last meeting he said, okay, now's the time to go ahead and put that, and you asked that it be in writing. And so what the commission has in front of it is not necessarily a prepared draft of a document, but it goes more to what Commissioner Jones just spoke about. Actually comparing the Constitution against the public comments, against what we as a commission wrestle with, what we think our role here is to give guidance to entities and covered individuals that are affected. And so what I'm trying to do in this is to offer some comments. It may not be comprehensive, but it gets very much to some parts of this Constitution, in my view, are absolute, that they apply to home rule cities and counties. And others, I'll tell you, I don't think apply at all. And others, I've gone out on a limb and I'm saying it's a good suggestion, but I can't see where in the Constitution it is required. And Mr. Chair, I can leave that document with you, or I can go through and quickly, not read my document, but quickly go through the sections if I can.
Why don't you kind of walk through and explain what
Okay.
your thinking is on this? I think your comments here are thoughtful and
The beginning place, I waited until I had gone back and reviewed all of the public comments that we've gotten, and they were good comments. And I think Commissioner Jones's draft dissent actually helped elicit a number of comments from those affected. So I think not only the draft statement, but her draft dissent has brought some comments forward. My beginning point on this actually took me clear back to the definition provision. Well, I've thrown in there, I think we need to cite in the main opinion, and you are correct. I am supporting generally the position statement and what it's doing, and I really honestly like the way the position statement has been drafted. The only thing that I saw missing in that is the organic nature of where home rule cities come from and where home rule counties come from. I just think that needs to go in. My beginning point is with the covered individuals, and this isn't something that's jumped out and frankly didn't occur to me until I had a chance to re-review the comments in view of our last meeting. And I have found in those comments one of the things that I think we need to be careful about in this definition of whether or not the provisions of Article 29 apply to home rule cities and counties, is I discovered a couple of those entities think by changing the definition of who is covered that they can move forward. And I am going to share with the other commissioners, I do not read in Article 29 the ability of a home rule city and county to come in and say, this doesn't apply to home rule city employees or home rule county employees. As I go through and review that, and that's an important point as you then attempt to apply those definitions to what is intended in each and every section. And so I'll begin there. I did change the order of the draft position statement and tried to follow the Constitution. The first one is actually the prohibition regarding money forbearance and forgiveness of indebtedness. And I want to remind the commissioners, as you look at that and compare that back against the gift ban that follows, there is no dollar figure. And I read that first prohibition against covered individuals truly as an absolute coverage. Although it's absolute, to Commissioner Jones's point, I do think there is a possibility of picking up all the exceptions that apply in Article 29 together with anything that has a rational nexus. And commissioners, I apologized, I use the word promote ethical behavior, but I think it's probably more to preserve ethical behavior. But I do believe that home rule cities and counties would have the authority to craft exemptions that they think preserve that ethical behavior beyond that. Similarly, and I think where more of the focus is on the gift ban. I have this on I now notice it's 2 2s here, under my second 2, getting to the gift ban. I've wrestled, and I think we have lots of responses from folks that are concerned that the meaning of our original draft position statement means everybody has to follow a $59 limit. As Commissioner Jones used some of the same language I've used, if you look at the crafting of Article 29, it puts in place a gift band. And that gift band is unlike other provisions of Colorado law. It does set a bright line test. And it is my understanding of the purpose of setting a gift band, without referencing the dollar figure, is that gives a clear indication to every covered individual what that line is. It also sends a message to members of the public that are out perceiving what is going on with these public officials and lets them know. One of the questions I've wrestled with is, okay, so you don't use the $59 limit in this. Clearly, all cities and counties have the authority to make that a stricter test. But I do think that there is some benefit for a universal standard. It just makes sense to me that members of the public would understand no covered individual in the state of Colorado, whether they're local government or state government, should be receiving a dollar figure over a certain amount. But I do not read in the Constitution that it would be an absolute limit. The $59 limit would apply to home rule cities and counties. But I do think it will be incumbent upon them to establish what that amount is. I want to remind the public, this commission did not select that dollar figure. It came to us in the Constitution. You know, we are not in a position to advocate that this amount is correct or this amount is incorrect. I'm just pointing out, I believe that when the language is read, that any city or county could make a stricter limit. That's clearly understood in the Constitution. I do believe it's permissible to have home rule cities and counties go above that limit, so long as they establish a rational nexus of how this would preserve ethical behavior. I've already touched upon how you would deal with the exemptions. Quickly on the lobbyist, we've had some comments from the public on lobbyists. As I read this section, this is an absolute prohibition. This is where it finally dawned on me that taking gifts from lobbyists not only reaches to elected officials, it applies to employees. If you follow the definitions selected and how that is thread throughout Article 29, I can't see that anyone would disagree. Now, the point has been made, some cities and counties don't really deal with lobbyists. Fine, go look at the language. The point is, no lobbyist that meets that definition. The commission has given guidance back in 2009 of what a lobbyist is, which goes through the Blue Book. I think that language has been established. I think it's was good rationale at the time. I don't see anything that changes that. And the point remains, cities and counties may not deal with lobbyists the way that state elected officials do, but the prohibition is against lobbyists giving those gifts. And so I don't see how anybody can argue that that's not an absolute prohibition. To point number 4 on the restrictions on representation after leaving the office, clearly, under the definitional structure of that only applies to state elected officials. And I don't want to go out on a limb and advocate that this commission thinks that applies to local officials, including home rule cities and counties. And similarly, on the makeup of the commission, and I think I've addressed it as number 5, I think there's a subpart A on the composition of the commission and a subpart B on what their duties are. But as to the composition, clearly Article 29 defines how this commission is going to be set up, and I do not read in that a restriction on home rule cities and counties that they have to have certain members from different political parties. That, together with the point that has been brought forward from the public that cities and the definitions of municipalities are by definition nonpartisan, I think at this point in time, I don't want to advocate that that would be a requirement on home rule cities and counties. To subpart B of what is it that the commissions would oversee, I think there has to be a process in place. I do not believe that process must mirror what this commission does. I do think general principles of due process and appeal rights and all of that is about as far as this commission could advocate. To the point that we would call the advisory function of this commission. Ours is actually dictated, both in the Constitution as well as the state statute, that we are, as a commission, to give guidance. Beyond that, this commission has chosen, under its own rules and regulations, to allow for position statements, what we're going through here today. I think it's wonderful. I think it makes all the sense in the world. We think it has a very Colorado flavor to that provision of law, that we would like to always give guidance in advance, under the belief that public officials, if they know what the rules are, will always attempt to follow that rather than to conduct unethical behavior. It's a great idea. I'd love to suggest every city and county out there follows a similar approach, but at the end of the day, I don't think the Constitution requires that would be a component in there. Lastly, and the original position statement doesn't get into it, but the penalty provision, and Article 29 limits what this commission can do, and in that is a provision that if there is a financial assessment, it is capped out at double the amount of the financial equivalent of any benefits that were obtained. That's where we are. In some ways, cities and counties can go well beyond those limits. I guess I really haven't opined whether that should be an amount, but in my view, that's kind of the floor of something. I don't know. I'm not going to argue hard for insisting upon penalties. If someone wants to make a case that a rational nexus for preserving ethical behavior would be the standard, I'd probably be very open to that. I have two other comments that are not in here that are kind of my verbal thoughts that I'm going to share. Because the chair started on the overall history of what I think the commission's concern is, I have two thoughts. One, I agree with the chair. Ms. Jones brought up the point. We think there is an amount that seems to be unacceptable, and I'll go a little further and say standards like giving up to 4 tickets with an undefined value a year, which one of the home rule cities and counties has come forward with, providing a standard we've seen from another home rule city that it's okay to have conflict of interest so long as you only do that one time per year. I think the commission is familiar with that kind of a standard. I may not be quoting it correctly, but it's literally giving a pass. The commission reviewed that in a context that hasn't been aired in public, so I'll be a little careful in how I go through that. But the case that you cited, the Eagle case of going off to the racehorse farm to review a proposal locally, those types of activities, if conducted, I don't care if they're conducted by anyone in the state of Colorado, they're gonna raise those questions and generally have a concern. I think at the heart of this matter, forget what the Constitution is. I think we raise the hackles of a number of local governments, some of them home rule cities, some of them home rule counties, when it comes to this notion of acceptable behavior in the context of studying a development. And the theory is it's okay to travel and go see and view this, which is absolutely educational, but the notion of accepting money from somebody that you're doing business with in the course of that, I think, is a question. It's not necessarily within the purview of our discussion on Article 29 and home rule cities and counties, but I think that is there. The second item that I am going to raise And the commission can look at this two ways. One is under the context of other standards of conduct. That's the way this commission always views it. But there are provisions, principally in Title 18, that are restrictions on local governments as well as state officials. We're very familiar with the cases that we have. And I'd like to hear from folks out there, but it's clearly my understanding that not only do those apply today to cities and counties, they also apply to home rule cities and counties. The legislature is also in authority to make changes, and those always apply. And it is at least my belief that those are in addition to the requirements of Article 29, and I'll stop my comments at that point.
Commissioner Sorensen, we haven't heard from you yet. I've got some questions, Matt, about your comments that I'll come back to them, but I think probably the best thing to do is see if Commissioner Sorensen has any questions or comments on this issue.
I tried to prepare by reading all of these materials, and I really appreciated the submissions by all of the local governments that were engaged, as well as organizations like Ethics Watch. I think they all raised issues that rang for me. I am interested in the difference between what the draft position is and the dissent opinion concerning review on a case-by-case basis. It seems to me that there is agreement about that somehow the Ethics Commission should be involved, but it should be on a case-by-case basis. Am I understanding the intent of the documents?
Commissioner Jones, I can, why don't we take turns and make sure we're on the same page? The way I'm sort of hearing the discussion today and the way I'm reading the dissent and Commissioner Smith's comments is that seems to be broad agreement, and I think there's always been broad agreement on the commission that there is a line out there somewhere that home rule cities and counties cannot cross without running afoul of the state constitution, because to do so would be a complete failure to address the matters in the amendment. So, for example, I think at one of our hearings, one home rule city, I think, made the argument that so long as the home rule city considered the question of whether there should be a gift ban and decided that there should be no gift ban, and that was their decision, that would be okay because they would have addressed the matter set forth in the amendment. There's really kind of no limit to that, so that you could have a gift ban of, well, just no gift ban. We considered and decided it was unnecessary. Instead, we have a provision that has no gift ban. It just says that you should not have a conflict of interest. That would be an example. I think, but where you draw the line really has been a discussion, and I've been an advocate, I would say, of sticking to the $59 because it's easy, it's predictable, everybody knows what it is. You don't have to review it on a case-by-case basis. I think Commissioner Jones, and we've had a very respectful discussion on this whole question. I think Commissioner Jones' view has been that there needs to be flexibility for home rule counties and cities, and that if someone brought us a ban that was different than the 59, as long as it was reasonable, that would be okay. I'm hearing Commissioner Smith's proposal to be something more like a $59 gift ban would be presumptively reasonable, and that if you're $59 or below, it would be acceptable, sort of a safe harbor of a gift ban. But that if you have a gift ban that exceeds $59, the burden of proof is on the home rule county or city to justify that amount as being reasonable and encouraging of ethical behavior. And presumably, those codes could be submitted to us for approval in advance, and we could issue statements on them. That was one of my questions for Commissioner Smith, would be how exactly, how would that work? would we judge the reasonableness of it in hindsight when there's a complaint, or would we review them in advance?
And before we get to the substantive discussion on Matt's position, I just wanted to address our new commissioner. In terms of whether or not it's a case-by-case analysis, I have a problem with making it $59 because it's easy to do. Our meetings could run smoother and our analysis could be smoother, but I just don't think that's what the voters intended, and I vehemently object to a $59 bright line test for ease of analysis. The other end of that is a case-by-case analysis. And that's what I have in my draft dissent. What I really wanted is to have a dialogue about it. I mean, we have public hearings, so the only way we're gonna have a dialogue is if we do it here. And where we were ending up, I think that we're ending up in the wrong place as the draft position statement is written. With Matt's comments, although I just said we weren't gonna go into Matt's comments yet, the concept of a rebuttable presumption of some sort is interesting. I think that is starting to head in the direction of recognizing that the voters intended home rule cities to have some amount of flexibility. I think that if we weren't able to get an agreement on what kind of line we wanted to have in the position statement, evaluating it on a case-by-case basis solves the issue of we can analyze the voter intent, we can analyze the city's intent, and then we can reach a determination as it's presented to us. So if we were to have a case-by-case analysis with some parameters for how you're supposed to do that analysis, such as what we saw in the Colorado Springs case, we would be doing our jobs. Now, whether it's the most efficient way to do our jobs is a different question, but I believe we would in all cases be doing our jobs if we looked at it individually. But I'd like to hear about ways that we could narrow this and not have to look at it individually. But I don't know that that's necessarily what we can do.
Mr. Chairman, you ask a great question, and I think that's a discussion this commission enters in on. Here's my personal thought. I think that issuing the position statement will give guidance not only to home rule cities and counties, I think it's going to give a lot of guidance to regular cities and counties. But I think in view of that, it would allow them an opportunity to, one, go ahead and reach the conclusion that they do and the rational connection of what, say if it's in the amount, et cetera. They would have a choice, frankly. One of those choices is potentially to make it easy and come to this commission, but I'm not suggesting to the commission that we are the ultimate answer. This answer may be given within the judicial structure of Colorado. Commissioner Jones made the point she's not trying to encourage a workload that really increases how active this commission would be. I think in view of the comments I've heard from other commissioners today, I certainly be open to entertain and try and facilitate for home rule cities and counties. But I do appreciate the fact that those entities are very, very, let's say, fond of being home rule cities and counties and don't necessarily recognize the jurisdiction of this commission to solve it. The practical answer is we might be an easy way to answer it and give them some comfort and guidance and input back. But I'm not going so far today as to suggest that we are the ultimate answer on what those limits may be. I think a lot has been gained. This has been a good public dialogue. The structure the chair put in place to really encourage. I mean, if we had taken this up, commissioners, and tried to address this in July based upon everything that we had in front of us at the time, I don't think we would be nearly at the level we are. But I want to thank the chair, because he's kind of guided this to encourage, finally, I think, a real dialogue on issues that all of these entities, I think they had an opinion. We just weren't hearing those opinions until now, and it's here. Mr. Chairman, I'll turn the question back around to you. I will share with you, I don't think that cities and counties would necessarily have to come to us to answer that, as long as they can prove the rational nexus test. That's one alternative. But I do suggest the ease of trying to work with them and committing to work with them in the future. I have no problem if that's the will of the commission. I'm actually advocating at this point in time that that's an open question, but it's a great question.
So let me, let's think through for a minute the sort of the practical, implications of all this and how it might come before us. There are probably, I think there are several things that probably would happen here. Let's assume for a minute that our position statement is adopted, that we end up adopting it either as written or with some modifications to accommodate some of the comments that have been made. One result of that, I suspect, would be that we would want to be proactive and have our executive director go out and accumulate all of the home rule city and counties ethics codes and ethics provisions, and work proactively with the cities and counties to identify things that may be problematic in their codes, and then give them a chance to revise them so that they can be compliant. A second thing that would probably happen is that we'd probably have some cities and counties that would want to submit their codes to us proactively and say, this is our new code, and is this going to, we don't want to be guessing about whether or not this is going to pass muster or not, so will you look at them? The third thing that's going to happen, I would predict, is that probably going to have some home rule cities and counties that reject the whole process and say, we're not subject to your jurisdiction. Thank you very much. We find your discussion interesting, but it's not applicable to us. In which case, we're going to have home rule city and county employees and officials who will be vulnerable to, complaints basically, and we'll be adjudicating complaints in hindsight, and we'll be saying, we'll be issuing sanctions basically. It'll be a two-step analysis. Our first analysis would be, does this home rule code meet the requirements? If not, we'll reject it, set it aside, and then we'll adjudicate the conduct under the constitutional amendment and our guidance. That seems like a little bit of a chaotic situation to me, because people aren't going to know whether they're compliant or not until after they've been sanctioned, and we'll probably have serial litigation with home rule cities and counties that don't like what we're doing, and that would be one possibility. So, look, I really do appreciate the urge to have some flexibility and consider, individual codes on an individualized basis, on kind of a case-by-case basis. And it's not for a lack of industry, I think, that I advocate a bright line test. It has more to do with, just a sense of consistency and predictability in our determinations. I mean, we have a constitutional amendment that sets forth this limit of $59 for gifts. And we don't have to argue about it in every case. We don't have to think about it in every case. We don't have to decide whether it was a good idea or a bad idea for the voters. And we apply it without exception to all non-home rule cities and counties. I'm trying to imagine what our meeting would feel like or be like on a day in which we had a non-home rule city or county here and an employee from that county here facing a complaint because he or she accepted a gift of $65 and we issue a sanction based on that, based on the state constitution, and then 5 minutes later, we have a case in front of us in which a home rule city or county employee received a gift of $150, and that just happened to be within the limit imposed by that city or county. And so we're sanctioning one person for a $65 gift, and we're passing the next person for a $150 gift. And it feels inconsistent. It feels arbitrary. It feels like it feels almost schizophrenic to me, because the voters have kind of tried to take all this from us by declaring in an amendment what amount is potentially corrupting. And so much as look, if I were king, I might even adopt something like the statute, that the legislature adopted, which was much more of a non-quantitative, judgment, sort of judgment-based approach to conflicts of interest, saying that we're going to examine conflicts of interest and say that we're going to examine them on a case-by-case basis. If I were king, I might not have adopted an amendment that said we don't care what the circumstances are. If you get a gift of more than $50, you violated the state constitution. Frankly, I don't remember whether I voted for this or not. but having it on the books makes it very, very difficult, I think, to do anything much other than say we're going to consistently apply this concept across the board. And I know home rule cities and counties don't like it, but don't like having that kind of a restriction applied to them. But I don't know, just for myself, I think it would be very difficult to pick and choose and on that particular point. So Commissioner Smith, a couple of the other points that I wanted to talk about, your thoughts here are intriguing and interesting. So for example, composition of a home rule board of ethics. It feels like we're all in agreement that every city and county has to have an independent commission.
Mr. Chairman, I have tried to ground, it's an attempt on my part to ground everything in Article 29, unless I can see it. And I have to be honest with the other commissioners, I really do not read into the actual language under that section that we have the authority to tell them what to do. And I understand that might defy logic as you just went through. It may not make a lot of sense, but in each of the comments I've offered, I've attempted. I mean, subject to dispute, people may disagree with what the language means, but I do not read in that section of Article 29 that there is anything there than a constitutional instruction on how this commission is created. And so I'm not trying to understand the logic. And maybe others can read it in there, but I am not reading that we have authority. I would even historically go through a series of ethical cases for all government, state, local government, and probably argue about this. The public has made the point that at least all cities are not partisan by definition, and I mean, I get it. It makes sense. It would make all the sense in the world to me that a local government would attempt to have some kind of an impartial group, a separate group, make that determination. I can't find the language in Article 29, and I have tried. I'm doing my best to let, as in many decisions, and I think the guidance we get from the court, look to the Constitution. And I'm not seeing it. If another commissioner sees it and can advocate that, I'm certainly open to listen, but I am not advocating that there is a set way in which a home rule city or county would have to set up a board. When I take a look at that section of the Constitution, but other than telling us what we need to do, I didn't see any excuse for me to read any more into it. It's open to discussion, but I don't see it.
Commissioner Bacon?
Thank you, Mr. Chair. And so, Matt, I can understand where you're coming from with the Constitution, but when it says address the matters, I think that the matter of having some sort of entity that hears the complaint and makes some sort of determination is really necessary. If that is absent, then any complaint ends up nowhere. I mean, you've got to have somebody hearing it and making some sort of determination. And since the Constitution tries to create a nonpartisan or an inclusive commission, I think that that's inherent in what we want. We want something as a commission that is somewhat independent of the people who may be the topic of a accusation or a complaint. And I think it would be wise for any kind of policy to have some sort of way to deal with it, even though Article 29 does not say that explicitly. The whole idea of a complaint going nowhere seemingly is not consistent with what the Constitution says and what I think that cities and counties ought to do.
And if I might just add to that, and then you can respond to both of us on that. So I think one of the approaches that we've seen from at least one city is to say, well, we're gonna have the city council adjudicate complaints against city council people. We'll just have the targeted or subject city council person recuse him or herself. And the the disinterested members of the council will adjudicate the complaint. I don't think that would comply with the amendment, because it's you could have said, the voters could have said that. They could have said, you don't need an independent commission, you just need a rule of recusal for conflicted members. And I suppose private boards of directors for private companies do that, but they get criticized for it. But I'm not attacking the concept. I'm just saying it's inconsistent with what the amendment has said.
And my response is, I respect that position, and I understand the basis on which it is made. I will tell you that where I have come from in these comments is trying to tie it to the Constitution. And I think we've received some pretty clear instruction from both the Court of the Appeals and the Supreme Court. And they, like this commission, bend over backwards to try and interpret the amendment. I do have, and perhaps others might want to make comment, but the point has been made, particularly for cities, that they are set up as nonpartisan. I absolutely accept the comment. They would be foolish not to take advantage of this situation, but I don't know that, in my reading of Article 29, that we could require it. I don't look at it as an absolute. I understand the logic, and I understand going through and trying to tie it to the bigger picture is in this, does it address the matters covered? And I respect your positions. I think there is merit in that. I just am telling you, from the research I've done, I struggle with that because I cannot make that tie-in now. I understand what you're saying, I respect it, and I'm just struggling with it.
You're an attorney, you go to the words. I understand where you're coming from.
I'd like to hear, Commissioner Jones, what you think on the independent commission issue.
I agree with Matt. I don't see that the constitutional provision as to how we, the commission, how we're supposed to be set up was intended to apply carte blanche to the home rule municipalities. I understand, I agree with the fact that it would be unseemly to have a commission that, or a investigative board that investigates itself and judges itself. But home rule cities and municipalities have voters who can vote and vote them in and vote them out and make referendums and so forth, that I believe the voters contemplated when they gave them the exception. So I get the feeling as to why you would want to have the Section 5 apply, but constitutionally, in terms of the four corners and what we're here to do and what we're authorized to do, I just don't see that it does.
So I would agree that the method of appointment, for example, is not necessarily applicable. We're not gonna have the governor and the Supreme Court appointing the members of home rule cities commissions. They have the freedom to decide how to do that, whether it's the mayor, the council, whoever appoints. But I do think, I really do, I feel very strongly that unless you have an independent commission, you're not addressing the matters in the amendment. I cannot conceive of truly addressing the concerns that were addressed by the commission, by the amendment, by permitting the body that is being regulated to adjudicate complaints against its own members.
And just to be clear, I understand where you're coming from, but to be completely honest with you, I'm not only looking at home rule cities and counties. I really don't read in this provision of Article 29 that we could tell any local government how to set up their adjudicative body. I frankly agree with Commissioner Jones that the risk they run for not doing this gets answered in a political election. I would certainly advise them to follow. Your logic is absolutely wonderful. It's just I've struggled in this constitutional amendment to find where, other than, as been noted by both of you, how else could you get to that conclusion after you read the whole of it? I accept that. I accept that reading. I just don't see it. I can't wrap my arms around it.
So how would we address this situation if we take that tack? Let's say that a citizen files a complaint with our board and says that, city council person, X, voted to give, his family business a permit. And city council person X came to us and said, sorry, you need to dismiss that complaint because that complaint was made to my fellow city council people and they found that I was just fine. It was okay for me to vote to give my own family a permit. And we said, well, wait a minute, that was, that was the city council, that's the regulated body. And the week after that, you voted that the other city council person could vote to give his family a permit. And then we went down the road and all the city council people's families got permits and each one of them, that city council person recused themselves and everybody voted in favor of it. And the argument was, well, you don't have any jurisdiction over this because city council adjudicated that. So you can vote them out of office, as Commissioner Jones would say. But that's always been a solution, right? Before there was Amendment 29, before there was Article 29, you could have voted the crooks out of office. Weren't the voters looking for something better than that, than vote the crooks out of office? Weren't they looking for some kind of a body to be put in place that could receive complaints from citizens and sort of exercise, neutral or ethical judgments about what was being done as a better way to address those kinds of things? To me, unless you have a requirement that there be an independent commission adjudicating these complaints, you really have gutted the amendment. I can't think of a more essential attribute. I mean, I agree with you completely that manner of appointment is up to the city. I agree with you completely that the size of the commission is up to the city. I agree with you that you don't necessarily have to have equal numbers of Democrats and Republicans because it's a nonpartisan board or environment, so maybe it's okay to have, political denomination is not so important. I agree with you that it's up to the city to decide whether that the city attorney's office should represent the board or not, or whether the city attorney's office should prosecute the complaints or not. I think there's lots and lots of details that are left to the discretion of the home rule cities. Just like we've taken the position with the legislature, state legislature, that the details of how we go about enforcing our rules are up to us, not up to them. But I can't get past the idea that there has to be an independent body that adjudicates the complaints.
I'll go ahead and offer, I accept that. I accept your rationale and everything that you're tying into that. I just want to respond that the criteria going back to what is covered in Article 29, back to those items, those matters could still come in front of that board. But, and maybe this is something that ultimately gets decided by the courts, but I am struggling with, in this case, trying to identify where in Article 29 that goes. And so I say to you that it may cause some chaos. We might take cases up. I would tell you if, and this looks like, I mean, if the discussion continues, one position is going to carry the day. And that position statement, of course, would not only guide the cities and counties, home rule cities and counties, but it'll guide this commission. And so this becomes a very important vote on what direction the commission wants to go. We might persuade each other that there is a better approach in doing this. I would say that the answer is, as to other questions that are out there, the commission might have a role, but I am struggling with the commission's role in how this entity is put up. I will tell you, I frankly see your logic, and I understand your logic, and I think it would be a huge mistake for cities and counties to not reach out for that impartiality. If I didn't say it in my comments, I should be saying it would be very logical, and it'd be really good to encourage ethical, not only ethical behavior, but respect within the community for maintaining ethical behavior. I get all of that. I'm just struggling with the language in the Constitution that gets me there. No, I don't struggle with your logic. I struggle with the language.
I have a question. I agree. I mean, of course how can we not agree that you would want a commission to be able to independently analyze, whether a ethics violation was committed. But a question I have is, and this might draw on your historical knowledge. I mean, this isn't novel. I mean, it certainly can't be novel for this commission. What have we been doing? And I asked that for the new commissioner. I'm second to the new commissioner. What have we been doing? We've been doing this, 6 years? I'm sure you've managed well.
Commissioner Jones, I will tell you that in my time on this commission, I am amazed that some smart person out in Colorado turns around and reads the same language this commission does and presents an issue that has never come before the commission before. And this issue, we've recounted the history. We did have the one case that was submitted several years ago that the commission started to work on, and it was abandoned. But outside of that, the commission really hasn't focused. And it is not unusual for this commission to take a year trying to wrestle with these. I think one of the most important jobs we do is to provide a good position statement, something that gives guidance. We may fall short on a couple of these items and have to come back and redefine them. But having an issue squarely in front of the commission. The only one we had disappeared.
So we don't have, I mean, so it's a hypothetical that you might have a city that wants to make its own assessment of whether or not it violated the ethics commission, that doesn't come up?
I will tell you, we have several things on our docket right now. But I mean, the chairman and Bob have both, they were on the commission when the other issue was here and then pulled away from the commission. But that's pretty much it.
I mean, I suppose that's the good news, but I'm just trying to understand the impact.
I mean, there's a little, some speculation on what I'm about to say, but it's not uninformed speculation. I think that first of all, it's a young commission, relatively young, so it doesn't surprise me too much that there are still some questions of first impression that are coming before us. But I think that I'm going to guess that the home rule cities and counties that have taken the view that this amendment was inapplicable to them have never been incented to come to us and present their commissions to us. The one that we certainly have been aware of, sort of in a general sense, is the Denver Commission. City and County of Denver's had its own ethics commission for a long time. No? I thought so. And I know that from time to time, certain attributes of that have come before, have been certainly discussed in commission meetings, but I don't remember ever hearing anything about that commission that was alarming. So, for example, there was an independent commission, there was an independent ethics code. I don't remember ever receiving a complaint about any City and County of Denver official or employee while I've been here. I think we have again, without getting into what's in our docket, I think that is new. The first time I remember this coming before us was when Weld County asked for an advisory opinion about whether this was the district attorney in Weld County had a disagreement with the Board of County Commissioners from Weld County. They had adopted an ethics code that he felt was clearly non-compliant with the state constitution. He believed that the Constitution was clear that it had to be at least as stringent as ours, and so he requested an advisory opinion. And that's the one that Matt says died for lack of interest. As we began to discuss it, it became clear to us that, before we started throwing down rules applicable to home rule cities and counties, we ought to get input from the home rule cities and counties and find out what their position was. And we went through a couple of changes of executive director, and I think that project floundered a little bit as a result. And it didn't really, to me at least, come into focus. Really, it was the request by the person who was both a state employee and a city council person that really brought it into focus. And as far as I remember, that was the first time we had a request like that, if that helps at all.
Okay.
But we certainly have no shortage of business before the commission now that's dependent on this issue.
Yeah.
And I think it's, I honestly think it's in part, it's a function of, I don't know, I'm going to call it erosion is the word I'm going to choose, or deterioration, but, if there are no rules in the state prohibitions have no meaning or have no applicability to home rule cities and counties, it's just a matter of time. Assuming that the voters were on to something when they adopted Amendment 29, that there was a problem with ethics in government, it's just a matter of time before the cities and counties chip away at this until finally somebody gets tired of it and says, wait a minute, this isn't even close to what the voters approved in Amendment 29. You've got city councils adjudicating their own complaints. You've got virtually no gift bans. You've got people being wined and dined and flown around the country by developers, and then they vote for development. What kind of we're shocked. How did that happen? And eventually people get angry again. And then now we start to see an influx complaints, so.
And just for the record, Mr. Chairman, I want to say the totality of that and that original case that came in front of us, you know, our focus here recently may not be on the punishment piece, but taking up the position statement, the totality of all of that. I don't know that we've gotten a lot of comments, but I tried to add the punishment piece in. Now I'm open to other suggestions. Commissioner Jones, I'm going to tell you, I was looking at this Constitution, and I'm going to admit to the other commissioners that when we finally get this done, I stumbled across some other language that frankly has never come in front of the commission, but I think there may be another matter that this commission will have to address at some point. I'll tell you, there's some very intelligent people in Colorado that have read the same words we're reading and brought forward questions that I don't think ever occurred to past commissioners as to what the meaning might be. And I am constantly amazed that this is not a matter that you ever completely close out. There's some wise individual that will look at that language and say, doesn't this language mean this? And it amazes me, you know. And it is a young commission, I guess, in some respects, but every time you think you've answered every question, let me assure you, it's not been answered.
Okay. Do you have, go ahead.
Yep, I just have one more thought. I'm following this conversation and the debate back and forth about that concept of independent commission. And it seems to me that's pretty key to the whole, the question that was put before the voters, and it appears in the Constitution. And so how you demonstrate that you have an independent commission may be open to interpretation and evaluation by a home rule community or any other community. But it seems that that concept of independence is really important. It appears numerous times. And I'm not as familiar as you are with this. I've only started really digging into it, but it just seems that that's a really key component.
Commissioner, if I can pass on guidance out of respect, I will tell you, search your own knowledge and experience in government and always trust your instincts. And there will be times that different commissioners, all well-intended and for good purposes, just disagree. But if I could pass on any guidance to you, look and know and understand, and other commissioners may be giving you some guidance, but I'd encourage you to fall back. That's the comment that was made before, is don't make this decision before you have a representative from local government. And we're very interested in your views, your perceptions, your understanding and experience in local government. So we will absolutely listen to what you have to share with us.
Let me propose to the commissioners maybe a way of moving ahead here. And we do have on our agenda an opportunity for public comment. We're not going to ignore that. We're going to provide some opportunity for that. But let me ask this question and see if we have consensus about it. Let me see if we can't get there like this. We have a draft position statement that we had looked at previously. I think in order to have a starting point, I'm still content with the draft opinion. Were we to take a vote now, I'd vote in favor of it. Let me get a sense of whether we have anyone else on the commission who would do that, and if we have more than one vote in favor of it, then I think the way we would proceed would be to have individual commissioners offer amendments to that position, and we can discuss those and vote on them. I'm not saying I'm necessarily opposed to some amendments. I think, Matt, in particular, the comments that you distributed, there's some points in there that I think I'd probably vote to amend, but rather than try and build those into the first motion, I think it makes sense to have a starting point and then see if we can't get enough votes to make some modifications to it. And Commissioner Jones, of course, you can vote for amendments or against amendments however you want, always reserving, your ability to dissent, to the opinion statement in its entirety or, as amended, however you want to do that. I don't mean to quash that at all or discourage that. So let me start by asking the question, amongst the commissioners, do we have anyone else who's prepared to vote for the position statement as it's been previously drafted?
Yes.
Okay.
Without any further amendments.
No. I
No.
think the chair said we could amend after.
Right, we
We'll
can
consider amendments. I think in the absence of an amendment being offered, what we're saying is we'd be willing to vote for this position statement as it's written, but we're willing to consider some amendments to it. And so,
But we have to move the approval of the draft statement and then listen to amendments, right? So we have to have it on the table?
I think that would be the Robert's Rules ways to do it, to have something pending and then begin the process of amendment.
Go ahead, Commissioner Jones. Want to?
I disagree. I, rather than vote for something that I still believe is insufficient and then amend it, I would rather have some dialogue to try to get to where we have something that we can agree to.
I think I may have misspoke. I think the process would be that there would be a motion to approve the draft position statement. We wouldn't vote on it.
Right.
But once the motion is pending and seconded, then amendments would be in order, and then we would start to consider amendments. We wouldn't vote on the position statement until we had considered all of the amendments. Okay,
Correct.
so we wouldn't vote for it and then start amending it. We would just have it on the table. So the next question is,
And to that end, I am very favorable toward this opinion, but it would be conditioned on some other modification that needs to come. But I'm very supportive of the draft that is out there, and, but may not support it in whole without some modification.
yeah, I understand. And if all the amendments failed, then you might vote against it.
Right.
And if too many amendments passed, I might vote against it. So,
Okay.
but at least we're moving towards a result. So, next question I have for the commission is the question of public comment. We have public comment on our agenda. We've had numerous instances where people have commented. I know that we have, Peg, I think, has signaled that she'd like to comment today. Question is whether or not is the commission prepared to and willing to accept additional public comment, give people an opportunity to speak, sort of one last time before we start moving and voting.
I would like to do that. I'd also like a 10-minute break, but I'd like to hear public comment.
I am very interested in comment. At this point, we've had a lot of written document. I would certainly encourage the public comment to be brief and to whatever point they want to make. We're trying to get out of here, and we'd like to be in a position to drafting a final document if that's possible.
Okay, let's do this. Let's take a short, we'll call it 10-minute break. I believe, I've been told that we have a noon hard stop for the room today. So we do have that time constraint, but let's take a 10-minute recess, and then we'll come back. We'll have an opportunity for public comment, and I'll ask, the speakers. How many? Can anyone raise their hand? How many public comments do we have today? 1, 2, 3, 4, 5, 6. Okay, so I'm going to ask that everybody, assuming that you've all been able to submit written comments, try and limit your comments to I don't know, 5 minutes, 3 to 5 minutes, something like that. We won't be enforcing hard time limits, but if you can try and keep your comments to within, say, 5 minutes, that would be helpful. So we can use the recess to refine your comments. If you have a 10-minute speech prepared, and again, if you need more time, we're not gonna be draconian about it. Okay?
I think what would be helpful for me, rather than reiterating what we've already read and what we've already agreed that we disagree to, but some solutions, if you have them, as to language that would maybe get us to a place where we could be in agreement. And that would just be helpful to me as a commissioner.
Okay. All right, we'll be in recess for 10 minutes until 10:30.
we'll do that.
Good, good committee. Sally's a good person. Her party left her.
Okay. We're back in session of the Colorado Independent Ethics Commission on October 13th, 2016. And before we went out on our break, we indicated we would have some public comment when we got back. So if you will step to the podium and identify yourself and what jurisdiction you're from, and tell us what's on your mind.
Good morning. My name is Winetta Massey. I'm the city attorney for the city of Colorado Springs, and I am here on behalf of my client, Mayor John Suthers. As you are aware, the city of Colorado Springs did submit a written objection to the proposed position statement previously, so I'm going to be confining my comments this morning to your conversation. And what I'm going to try to do is pull some strings out of that conversation and connect them up to help you better understand why the home rule cities have taken the positions that they have. The Constitution is indeed the organic law of the state, and it addresses various matters. Executive branch, legislative branch, judicial branch, home rule cities, ethics, and the FCPA, okay, Fair Campaign Practices Act. The Constitution, and I heard a comment this morning, doesn't necessarily conflict between the ethics and the home rule. But what I think the Constitution has done is establish the lanes in which home rule cities need to operate and the Ethics Commission needs to operate. Interpreting legislative pronouncements is one thing, interpreting constitutional matters is something entirely different. And I am very pleased to know that the Commission is honestly trying to figure out what the voters meant. Pretty much every day, any city attorney in the state's trying to figure out the same thing. What did our voters mean when they enacted our charter? What did the council mean when it enacted an ordinance? And so we go through these exact same legislative construction exercises. You have done the right thing by looking elsewhere in your organic document, the Constitution, to see where there is similar language. And you found it in the FCPA, Article 28. I'm going to get the numbers wrong and I'm going to get the letters wrong, so bear with me. And Article 28 has very similar language to what is in Article 29 with regard to home rule municipalities have some authority, and if they address matters that are addressed in this article, they basically get to opt out. So you went looking, as is the practice, for any case that would help you understand what that language meant, and you happened upon the case regarding the City of Colorado Springs and a complaint under the Fair Campaign Practices Act. And having been a party to that case and knowing the other side of the story, what happened after the case came down, I think you will benefit from this interpretation of what that case meant. The City of Colorado Springs had adopted a Fair Campaign Practices Act that basically said, we're adopting the state's Fair Campaign Practices Act, right? Same standards, everything. Except the City of Colorado Springs had an additional provision that said, we have penalties. There may be some criminal prosecution in our municipal court. We received a complaint regarding a campaign practice during our last election, or 2 cycles ago. And under what we thought we had adopted, we took the complaint up to the state, because if we adopted their Campaign Practices Act, they're going to be enforcing it. The ALJ said basically, nope, that doesn't work, it's all or nothing. If you adopt it, it's yours, you have to enforce it. We appealed that to the Court of Appeals, and the Court of Appeals said, yep, if you adopt it, it's yours, you have to enforce it. The part of the story you don't know is that after that case came down, we said, all right, we'll take responsibility for readopting our FCPA. And we had several, not intense is the wrong word, I will say deliberate and far-reaching public conversations with our council about, so if we're gonna do this, do we like everything that the state provides in the Constitution, or is there something different in our local jurisdiction that makes sense for us? And sure enough, there were two distinct points that differed from the state constitution, which may or may not surprise you, but in Colorado Springs, we allow candidates to accept donations from corporations and labor unions, which is not within the state FCPA. But we adopted it, and we're enforcing it because it's ours. And because within our home rule lane, when we're talking about fair campaign practices, the language in that portion of the Constitution says if we address matters, contributions, where do they come from? Are they authorized or not? And how do you enforce? Then it becomes ours and we get to enforce it. And that's exactly what we've done in the context of ethics. Within our home rule lane, in 1991, we enacted a code of ethics, and our code of ethics was an aspirational code, and it said no financial conflicts, avoid the appearance of impropriety, you can cure the appearance of impropriety with disclosure. And that's how we operated until 2006, when there was another amendment to the Constitution, Article 29, and it said, you must address the same matters. Okay, well now we know we have to have enforcement. We know we have to have an independent ethics commission. We know we have to have some type of gift ban. And again, another public process. We had a committee that worked on our new code of ethics. We had several sessions with the city council. We adopted a code of ethics. Our code of ethics adopts some of the same provisions, but it doesn't necessarily adopt all of them. We don't have anything regarding lobbyists. We don't have anything regarding activities after you leave an elected position. And we certainly don't have anything about partisan political appointments to the Independent Ethics Commission, because our charter says we don't have partisan elections in our city. If we can't have partisan elections, I don't know how I can advise my client to turn around and have a partisan board. So we didn't adopt those because we addressed the same matters. And the minute we did that, we were back in our home rule lane. And so when we talk about the importance of our home rule authority, what we're really doing is we are respecting not only the voters of the state who enacted Article 20, Section 6 of the state constitution, but we're respecting our local voters who enacted our city charter in 1909 and have amended it off and on throughout the years, and who publicly participate in our council meetings, who elect their representatives to sit there and determine what is in the best interest of the city. Did I advise my client to operate within the confines of the Constitution? You bet I did. We're a home rule city, we get to enact our own ordinances. Did I operate within the confines of the Constitution with regard to our Independent Ethics Commission, our ethics code? Yes, I did, because we addressed the same matters. We didn't do it the same way, but we did what was appropriate for our jurisdiction, which is the whole purpose of the Home Rule Amendment. I have a feeling that you will hear some of these same similar comments from the other speakers who will be here today. But my point is, when you look at the really big picture, the Constitution speaks on several matters. And it says, with regard to cities, if your citizens trust you enough to let you organize and enact a home rule charter and operate government where you are, you have a duty and obligation to do it. And that's what I believe most of the attorneys for home rule cities within the state have been doing since 2006, when Article 29 was enacted by the people. We're respecting the people of the state of Colorado, and we are respecting our own voters by having an ethics code. And if you all have any questions at all about how we, operate differently, I will tell you that in the last year and a half, we have had 3 matters, two specific matters that went to our Independent Ethics Commission. They hired a hearing officer, or they made a recommendation to our council hired a hearing officer. And it went back up to council. Council made the decision, and some sanctions were imposed and some were not because they didn't find ethical violations. But that's what works for our community. That's what our citizens envisioned when they enacted our home rule charter. And all I'm asking on behalf of my client is that you respect the lane that we're in as well. And when your organic law says, if we've addressed the matters, that Article 29 does not apply to the city of Colorado Springs or any other home rule municipality, that you respect that. Thank you.
Good. I think we may have a few questions for you, Winetta. Thank you for your comments.
So do you have any, what do you suggest we do for language that keeps people in a lane rather than nothing?
Well, I kind of think what you did, the position statement as it is, started to parse the language of the article. Just like we tried to do with the FCPA, you know. We enacted it, we have an additional penalty, but we're gonna send it to you. And the Court of Appeals said, no. If you take it all, you gotta deal with it all. And even in your conversation today, you're talking about, well, we're not gonna tell you how to select a commission because it doesn't really apply. Or we're gonna, yeah, you need people on an ethics commission, but they don't have to be partisan. So you're starting to even now parse through what the Constitution provides with regard to ethical conduct for government in Colorado. And so I don't know that there is a good answer other than your position statement would be you will opt out if you address these general matters. Do you have an enforcement mechanism? Do you have some type of, independent ethics commission? But in reality, considering the spectrum of municipalities that you have, home rule municipalities you have in the state, some are very tiny and some are big. And the big ones don't have a problem finding people for an independent ethics commission. But even then, we have to have alternates because they could know somebody or, they may need to be recused off. You're not going to find that in a small town. So I think it's going to be hard even on just that topic to articulate how you've addressed the matter, other than there's going to be some independent group that reviews these things and makes a recommendation or makes a decision. But then you got to leave it up to the municipality to figure out how that functions in their community. So just as an example on that topic.
Let me press that a little bit farther, because I think you mentioned that you guys went through the amendment and figured out the parts that you had to conform to or decided to conform to. I won't try and spin what you've said, but I think to follow up on Commissioner Jones' question, it sounds like you were starting to go down the line of what parts of this amendment are really essential, and some form of independent commission sounds like.
That was essential for us.
Okay. What else? What other parts of the amendment did you identify in your process that were sort of essential that had to be addressed?
Our code of 1991 did not have anything about a gift ban. We thought a gift ban was appropriate, so we adopted a gift ban. Our 1991 Code of Ethics did not have any enforcement mechanism. It was aspirational, as I said. So we now had to have an enforcement mechanism that involved an independent ethics commission and some type of sanction, some range of sanction that was available. So we looked at those big topics, and if it was something that was addressed that appeared to relate to ethical behavior in government, we needed to address that general topic in our local Code of Ethics.
And what did you do for a gift ban?
We have, of course I don't have it in front of me. We have a gift ban that initially adopted the states, and then it escalates per the state, so we escalate it, and I think it's at $59 right now. But there are also meal bans, there travel issues. We have a lot of exceptions to that as well. For example, if our police department has a community event every year that honors our Medal of Valor recipients, and so it is not a violation of our gift ban to accept gifts for the purposes of conducting the Medal of Valor luncheon, or the police officers will be hosted at a table that was purchased by some not-for-profit or a for-profit entity, and that's an exception to our gift ban because it is a topic and event that is important to our community, and as we analyze that, and the public conversation was, no, we think it's appropriate that be an exception to a gift ban, as an example.
Okay. I mean, it sounds like what you do is very similar to what we do, so we haven't examined your your code yet, but two questions. One was, does your independent commission decide complaints, or does it just make recommendations to the city council? And what does it do when a member of the city council is the subject of a complaint?
That's a really good question. First, part of that question, the Independent Ethics Commission receives and reviews all complaints. Frivolous complaints are dismissed and kept confidential. Non-frivolous complaints for which they have jurisdiction are investigated by the Independent Ethics Commission. The Independent Ethics Commission makes a recommendation to the council, and the council has the option of hearing it themselves, appointing a hearing officer to hear the item, but council ultimately will impose the sanction for covered persons, as we've defined the covered persons. And one of the two ethics complaints that the commission was dealing with in the last year or so did involve a sitting council member. And that process went through an Independent Ethics Commission. They investigated. They made a recommendation that they had found at least one violation of the Code of Ethics. The council engaged a hearing officer, and the hearing officer conducted a public hearing at which the allegations were reviewed, considered. The hearing officer recommended or found a violation and recommended sanctions to the council, and the council accepted the finding of the violation, and they imposed sanctions.
Real quick, your covered individuals, do you follow what's in Article 29, or are you recrafting those definitions?
We define covered individuals as all elected officials of the city, all administrative officers of the city, which are defined by our charter, employees, board and commission members, and all volunteers.
Okay. And second question, a little out of this, but I think it'd help me with a little guidance. The general matters under Article 18, is it your view that you're exempt from those, or are you under Title 18, or are you under those just like any other city or county?
Title 18 are criminal matters,
Okay.
which we find entirely separate and distinct.
What's the conflict stuff, do you know? Conflicts of interest, standards of,
Title 24.
I apologize, Title 24.
Uh-huh.
Yeah, Title 24.
With regard to
Yeah, do you read any exemption for home rule cities and counties under Title 24?
I have not reviewed that in
Okay.
this context.
And I'm not trying to
Yeah.
hold you to it.
No,
It's,
And I will tell you, though, that we have, as a result of the allegations and the
24-18.
complaint against the sitting council member, there was a question as whether or not there was some criminal culpability there as well.
Yeah.
And so we have had a long conversation with our council regarding ethical violations, which are clearly within the city's code of ethics and something that we believe that our city needs to address per our code of ethics, and criminal violations that may implicate an ethical violation but would stand alone as a criminal violation.
and thank you, I appreciate that analysis. And just to be clear, I meant Title 24, Chapter 18.
Yeah,
So,
okay.
okay,
My
thank you.
apologies.
And just, again, hopefully the last question. It sounds like the area, at least in our draft position statement, recognizing there are some, I'm not trying to unduly simplify what you've said, but the one that sticks out to me that I heard was restrictions on representation after leaving office. I think our draft position statement includes that a compliant home rule code will include some restrictions on representation after leaving office. Do you have no restrictions on representation after leaving office? Okay, so that's the only one that I've heard so far that would strike me as inconsistent, really. I mean, what you've
Right.
described is very similar to what we do. I mean,
Right.
you're,
But again, that was our choice.
right, I
You know,
understand.
after we go through that whole exercise, that is what our community determined was an appropriate regulatory scheme for behavior of those who are involved with our government.
Can you tell us why, a little bit?
On the code of
Why it is that you decided that you didn't need to have representations after leaving office, or any restrictions on leaving office?
Well, and keep in mind that I was not in charge of this project in 2006, even though I was with the office at that time. My guess is it hasn't been an issue. And if it becomes an issue, we can always change our code. Because again, with our municipality, an ordinance to amend the city code and the code of ethics is only 2 readings. If it becomes a problem, we can get in and fix it. But I have no personal knowledge of an instance where there was some type of undue influence from a former city council member or a former city employee that would implicate some corruption or some inappropriate behavior.
Well, maybe we're talking about 2 different things, because there's the state statute that puts a sort of a restriction on post-employment employment, if you will, first under Title 24 that says
Okay,
you can't leave and go represent somebody that had business with the state and, essentially, feather bedding.
Yeah.
Do you have something like that?
we don't have anything like that either, but again, you need to, as a home rule city, up in Article 1, Chapter 1 of our city code, we have 2 really good ordinances. And the first one says, as a home rule city, we are specifically superseding any state statute that conflicts with whatever we've decided to do that is within our local and municipal concern, number 1. The second ordinance says, and specifically, we're exempting ourselves and superseding these specific statutes. So as a home rule municipality, if it conflicts with something that we have done that is a matter of local and municipal concern, that it is not something that's within our purview.
So, I don't mean to have you use up everyone's time, but
That's okay.
your
Sorry.
comments have been helpful, and I think we'll probably hear about this from the others. We're familiar with the Fair Campaign Practices Act case and that jurisprudence, and so let me, rather than be obtuse about it, I'll be direct about what I think about it, and then you can tell me that I'm wrong, or other people can tell me that I'm wrong. But my view has been that local elections are a very different animal than the ethics issues that are raised by Article 29, in the sense that I can understand the argument that local elections are truly a matter of local concern. And that the local code doesn't apply to state elections, state representatives, county elections, whatever. So that the reach of the local campaign code is truly limited in geographic extent to elections for that area. What I've had a hard time getting my head around is the idea that it seems that by definition, with the adoption of Article 29, and by definition, these specific provisions that address all cities and counties in one clause, and home rule cities and counties in another clause, that the voters have adopted the issue of government ethics as a matter of statewide concern. And my understanding always of the law has been that when you have a matter of statewide concern, that even home rule cities are not free to do whatever they want. What do you say about that?
Well, I would say that Amendment 29, or Article 29, did not specifically say that Ethics and Government Amendment 481 was a matter of statewide concern. And while we understand that the legislature on occasion will declare something to be a matter of statewide concern, most municipalities will take that with a grain of salt because that's the legislature's opinion, and until the court speaks on it, to Commissioner Bacon's point, it doesn't really affect us. I mean, and that's why most home rule cities will say we've superseded it, and unless it really is a matter of statewide concern, and I get, the majority of the Supreme Court to tell me that, it's not a matter of statewide concern. I would also say that, like the FCPA, the Code of Ethics does have that provision in there that says, we understand there are home rule municipalities out there, and as long as you speak on the matters that are addressed by this article, you can go and do and be as you see fit. And I think right there is basically your answer, is that even the citizens of the state of Colorado recognize that they have another constitutional provision that allows these home rule municipalities to speak on matters of local concern. And with that language, in both the FCPA and the ethics amendments to the state constitution, the voters recognize that those local jurisdictions have a right to determine what ethics and campaign practices ought to look like in that area, or else that language wouldn't be in there.
Well, so let me press this a little bit farther, and again, I think this is helpful for everybody, because I'd like to hear other comments on this as well. But I guess what my reaction to that would be, number one, when the amendment says that home rules, that we will lack jurisdiction only with respect to those home rule cities and counties that have addressed the matters in the amendment, I still haven't heard. That seems to me to suggest that the voters expected us to assert jurisdiction as to those home rule cities and counties that have not addressed the matters. So I don't think it's so simple as to say the voters have just carte blanche exempted out all home rule cities and counties, but there has to be a standard implied in that language. That's the way I read it. And I try though as I may, I haven't been able to get around that.
Right.
And I guess the second thing I would say would be there is a different structural framework here that I think sometimes people lose track of. I don't think that we have the ability to say, well, it's not our affair, some court somewhere sometime will decide all this. Because by definition, matters of ethics complaints or ethics issues that arise are either within our jurisdiction or without it. And if we feel that a home rule city or county charter has not addressed the matters in the amendment, it's within our jurisdiction. And I think it's incumbent on us we have to decide. I don't think we can duck the issue and say, well, we'll deal with it if a court ever tells us to. And part of that is because we're a constitutionally created body. And this really is a fundamental difference. And we went around this with the legislature last year, and we went around it with a couple of litigants, and we ended up with these decisions from the Supreme Court. So things like, does the Colorado Open Records Act apply to us? I think the answer is probably not. Does the Administrative Procedure Act apply to us? The answer is clearly not. The Supreme Court has ruled on that. And the reason is because if you allowed the legislature to regulate things for this commission that's constitutionally created, then where do you draw the line? I mean, once you cede authority to the legislature to regulate what we do, how we do it, who does it, whether we have separate prosecutors and separate judges, whether we refer things to administrative law judges, then you allow encroachment on the independent nature of the commission. And so, again, and I'm not really, and I've always taken pains to say, I'm not necessarily defending this as a great public policy, and I've probably been one of the most outspoken quasi-critics of the amendment as it's structured, and have been an advocate for us holding hearings on how we could make this a better amendment, and submitting something to the voters to amend it and revise it. So please don't take my comments as a moral statement about what's the right public policy. But I do feel that we have an obligation to defend what the voters have done to the extent that we can. Until it's changed, we have to defend it. And so, the way I would see this spinning out in the courts is that this commission will have to make a decision. Let's say we do end up with a case-by-case approach, and we decide that XYZ city's code does not meet the requirements of the Constitution. There may or may not be a lawsuit, but then the question becomes, when this goes to the Colorado Supreme Court, what exactly are they deciding? They'll be deciding whether we have the right under the Constitution to make that decision in the first place, whether or not what they're reviewing is some sort of administrative review of what we do, or whether or not they owe deference to what the commission decides with respect to what this amendment means. I think what they will decide based on their prior decisions is that because we are an independently created constitutional commission, they owe deference to us in terms of the interpretation of the amendment, what it means, and to whom it applies. And so that's one of the reasons we're being, as I think, trying to be as thoughtful and comprehensive as we can be, in making this decision, because we don't want to make a dumb decision, because we recognize that it may have important legal consequences. And I don't know about what the other commissioners think about this, but I, for one, I'm not prepared to cede. And it is a strange concept, I will grant you, because we've all been schooled and tutored in the belief that, the Supreme Court is the supreme law of the land and the interpreter of the laws, and the legislature is the enactor of laws, and all agencies are subject to what the legislature does. But we've already established through Supreme Court precedents, it's not true for this commission. And it makes sense to me that it's not true for this commission. Whether I like it or not, it makes sense to me. So,
Could I respond real quick?
yes, mhm.
Colorado Springs has actually been sailing those same waters for 117 years. The legislature always tries to tell Colorado Springs and other municipalities what they can do and they can't do, right? Okay, so we're on that same page. We too are a constitutionally authorized body. And we don't want the legislature regulating us. You don't want the legislature regulating you. So I understand what you're saying entirely, and I do think that judicial resolution of some of these questions really is the only way to go. But I think part of the reason that the municipalities have said, wait, you need to stop for just a second, is because you're getting too narrow. If you said, we interpret, address matters in your code the same as in the article, and you said, here are the topics you need to cover, I don't think anybody would object to that too much. What we're worried about is you getting down further and saying, and on the topic of an independent ethics commission, you must do X, Y, and Z. Because,
And let me interrupt you on that, and
Okay.
I get that, but so let me make it real concrete. Supposing, and you have one example in your code that's why I focused on it. Supposing that the Home Rule County says, we have considered and addressed the question of a gift ban and decided not to have one. I mean, I would say, sorry, you can't do that, and you have to have a gift ban. May not, even if we accept Commissioner Jones's dissent and suggestion that $59 isn't the right answer, there might be other answers, and we should review them on a case-by-case basis. Or if we accepted Commissioner Smith's proposal that there be a rebuttable presumption that anything, $59 and below is reasonable, we're still in the same business of adjudicating whether or not the amount of the gift ban is reasonable. Would you take the position that if the city said, we've considered it and decided not to have a gift ban, just as you've considered and decided not to have a restriction on post-employment employment, that would be within the province of the Home Rule City?
I would say yes, because that's exactly what Colorado Springs did with the FCPA. We adopted a provision that was prohibited by the FCPA.
Yeah, all right, so, and I know you're not, you've
Yeah, no,
You've
but-
made your comments in a very reasonable way, but that's why I asked the question. The purpose of the question is to determine whether or not this really is a slippery slope. Because if I accept the full breadth of what you've said, the logical conclusion of that is, if a home rule city decides that we've considered it and decided we don't need bans on gifts, we don't need bans on employment, we don't need bans on whining and dining and entertainment, it's the Wild West and we'll just be accountable to our voters, then we would have to defer to that. I cannot get my head around that. I don't think that's what the voters intended, and I don't think that's why they created this independent, constitutionally created Board of Ethics. I just,
Now, on the same note, you're asking her what are her thoughts if there's a zero ban, because it differs from what's in the Constitution and what's in our position statement. But she didn't say that their gift ban is $59. She says it's $59 with a series of exceptions. So it's the same distinction as if we're saying it's got to be $59 in our position statement. Anything that's other than that is contrary to our position statement, including making exceptions for the police valor luncheon. So if we want to be able to say exceptions for the police valor luncheon falls within matters addressed, the matters addressed exception, then that's a case-by-case basis. That's okay. Yes, we agree on $59 having exceptions for the police and the luncheon, but we don't agree on exceptions for zero. And so to me, that's how the commission is that's what the voters are expecting us to do. But I would like to hear from other cities to see, what they think.
and the only thing I'd say to that, Commissioner Jones, is we've considered the police valor issue here, and we had a robust debate about gifts to the Police Protective Association and collecting money for fallen officers and all that, and we've issued opinions about that, and we've sorted that out as exceptions under the state constitution. That's why I say virtually everything you've said today is consistent with the jurisprudence of this commission and the published opinions that we've had, save for the decision that we've decided we don't need to have any post-employment restrictions. And so that's why I'm focused on that, as to whether, how far how far do you press this argument that the home rule cities have the power to deviate even to that extent? It's not just a question of what will the flavor of the restriction be, but the discretion goes so far as to throw it out completely. And I really do think that the way this position statement is drafted, the intent of it is to identify those core concepts of the state constitution as to which there must be something without micromanaging the codes. And I think those are the flavor of the amendments that Commissioner Smith is going to propose. But
Because otherwise, you're saying the way our position statement is drafted without amendments goes against our previously issued opinions.
no, I don't think so.
I don't think it goes that far.
But if we have a $59 gift ban, then that's it. But then you're saying we have opinions that we've written previously that allow for you to spend more than $59 on police issues. How is that not a conflict? That,
Well, we don't have any opinions that overrule the $59 gift ban, but we have lots of opinions that interpret what it means and how it's implemented and how it's applied. And we've got really a whole jurisprudence that's grown up around this commission that's now reported in the red books, the revised statutes, that helps people understand how we're interpreting and applying those provisions. So,
I guess I'm
and I don't think the position statement isn't a reversal or a discarding of all of that jurisprudence. But it does repeat that there has to be a $59 gift ban. One of the questions you've raised is a legitimate question, which is, how do we and to what extent do we import all of those decisions and interpretations that we've adopted over the last 6 or 7 years when we're reviewing the adequacy of a home rule city or county ethics code? Because, and all I can say is the same, you basically do it the same way everybody, drafts their codes to comply with the law. You look at the amendment, you look at the decisions we've made, you figure out what's important about this amendment that has to be in your code and what's not. You look at our position statement and get guidance from that, and then you draft something that you think complies. And we have a mechanism built into our system by which you can present that to us and say, what do you think of this? Do you think this complies or not? And if we say yes, then it's over, and everybody goes along their merry way, and the cities can administer their codes and as they're entitled to do under the home rule. But I think that would be the process.
just for clarity, I understood her comments to mean that if the police get a gift of $100 luncheon, that's okay. And that's an exception. And then I understood your comments to be, we've already approved exceptions for policemen. So if it's not above $59, so I'm saying, do we have opinions that say policemen can get gifts above $59? Because if not, then my comment remains that we have I don't understand.
No, I think we have an opinion out there that allows the police to go out and solicit contributions to a fund that's used for injured and fallen officers and their families.
Right.
And they came to us and said, we'd like to know whether or not this is okay, because, on its face, we can see an argument that this violates the gift ban, because people are giving gifts to public employees, and if the $59 means you can never give a gift of $59 or above, then that would be a problem. And so we had a big deliberation about it. And even though I expressed some skepticism about it, we ended up all voting in favor of an interpretation of the amendment that would permit that kind of activity. And that's just one example. There's a whole host of decisions out there that modify and have interpreted the amendment. But the question really before us today that we have to decide is, are we, is the state amendment, is the state amendment set minimum standards for all cities and counties that have to be dealt with? So,
Could I just, I would like to tee up this issue and have somebody else kind of speak to it. But the other thing that I've heard is that whatever the minimum, not standards, but the minimum issues that must be addressed by local codes of ethics, whatever they are, I've heard that you want to review those to make sure that they comply. And I would submit that that is a serious interference with our constitutionally authorized legislative authority of our councils. I mean, what you're basically saying is they're going to have to pass an ordinance that says, here's what's in our code of ethics, submit it to you, and if you don't like it, we have to go back and pass another ordinance and change it because we didn't address your matters. So I would just, and I would really like to hear what some of the other attorneys have to say about that, but you need to kind of, again, respect the lanes that we've been given. And so if we have an opportunity through your constitutional amendment to address those matters and then handle it on our own, we want to be able to do that.
Okay, thank you. Who's next?
Good morning. I'm Kathy Haddock from the Boulder City Attorney's Office, one of the attorneys representing the City of Boulder, and appreciate the opportunity from being here. And since I've only been with Boulder for a short time and practiced in private practice for small cities and towns for 25 years and lobbied with Sam in the legislature, I know that every time that I come from Boulder, that there are Boulder's the wingnut, or Boulder's the one far out left, or whatever. Whatever you want to say about Boulder, one thing I can assure you of, and you can look at the codes and find it out, that there are 3 areas where Boulder is incredibly conservative. That is on their fiscal policy, on their dedication to transparency of government, and on ethics. And they have a very strong and detailed ethics code that applies to employees, officials, boards and commissions, everybody that says, I work for the City of Boulder or I represent the City of Boulder in whatever limited capacity it may be. The other thing that I think in where you're struggling, and I guess I'm going to follow up the theory of staying in our lanes, we all have opinions of what's right. And frankly, I agree with a lot of what you guys have said about, you know, there should be this, there should be that, there should be so-and-so. But I'm not queen. And your constitutional provision doesn't give you the authority to step in to decide those things. When your constitutional authorities say the requirements of this article shall not apply to home rule cities if they've addressed them, the requirements of the article means all the requirements of the article don't apply. And that may seem crazy, and we may disagree with it or whatever, but that's what the statute says. And that's what the Constitution says. And this is not an issue of my constitutional authority and creation as a home rule city can beat up your constitutional authority as a creation as an ethics commission. It's not an issue of you were created sooner than home rule cities, so you have priority. I can argue that older is better. The thing is that we have to realize that we are a nation, hopefully, of laws and not men. And the laws here, and women. The law here is pretty specific that it doesn't apply to you, that you cannot impose your things either by reviewing our codes or saying that they have to have minimum things in it. So when you're determining conflicts, to the extent you want to say that the 2 sentences that we're interpreting are conflicts, you have to look at the rules of construction. And the rules of construction include giving effect to all portions of the language, not creating a conflict if you can construe them in a way that there is no conflict. And if you can't work it out from that, you go to the legislative history. The legislative history on this, particularly with the Title Setting Board, is incredibly clear that when it says the requirements of this article shall not apply to home rule cities that have adopted charters and ordinances, that's what it meant. It does not apply. You do not get to be a super body over home rule cities. So, I mean, all due respect, I'm sure you do a great job, and I agree with what a lot of you said, but we are a state of laws, and the laws say that home rule cities are created by the Constitution, and they are controlled by their people, not by the legislature, and not by independent commissions unless they're given the specific authority to override the home rule cities. In this case, not only have you not been given that, but you're specifically not been given that.
Let me ask you a question about that. So when this amendment was adopted in a statewide referendum. It wasn't adopted in a countywide or a citywide referendum. It was adopted in a statewide referendum. This amendment could not have passed without the votes of tens of hundreds of thousands of voters in home rule cities and home rule counties. Do you really think that when those voters voted in favor of this amendment, what they intended was the city and the voters of Boulder intended that we want this set of ethics rules to apply to Lyons and to Otero County and La Junta, but we don't want these ethics provisions to apply to the people in Boulder? And if I apply that across the whole state, do you really think that the people that were voting for this, and 80% of whom are resident within a home rule city and a home rule county, intended that we need this constitutional amendment to control the miscreant behavior of those 20% of people out there that are not in a home rule city and home rule county, and that's all this amendment was intended to do? Impose ethics standards on everyone else but us.
Yes, I do. And I have several reasons for that. One is that there's a lot more that is covered by Article 29 than just city or home rule cities and counties that have not addressed ethics issues and statutory home rule cities. I think the voters in Colorado, just like every state, are very concerned about the ethics of other levels of government and other people and however you want, all the other people that you cover. I think that's why they voted for it. I think then this is borne out in Boulder very strongly that the people of Boulder would much rather go to their city council and try to get the city council to change the ethics code for the city of Boulder than they would to go to the legislature or to pass a statewide referendum or to come here to you and try to get you to say something different. The voters of the city of Boulder often, and we have 4 amendments this time to our Constitution, to our charter on the election in November. It's easy to change the law in Boulder if people want to. And if it's enough of an interest that has enough, it is not easy to change the mind of all of you or the mind of the legislature or to put another constitutional amendment on the ballot. I think that's exactly why this sentence is in here.
Okay, thank you.
The thing you've asked for specific comments on, I'm sorry, were you going to ask a question? Okay. You've asked for specific comments of what we think that your statement of position should be. I think that it should be that you're going to honor the Constitution, that you are going to, that you are not going to assert authority over home rule cities and counties that have adopted their own ethics codes, because that's what the Constitution says. I completely understand that you don't personally agree with that. And I get that. There's a lot of things in the law that I don't personally agree with. But I think it's vital that you lead the charge in ethical behavior by following the law and staying in your own lane and not trying to exert your authority outside of where you've been given jurisdiction.
Are you done? Mr. Chairman? Just really briefly, thank you for coming and thank you for offering your comments. I went back through and I didn't find any submission from Boulder. I think you explained you're kind of new and everything. And I really don't want to argue with you, but our hearings in July were very focused on the Blue Book and that language and trying to get our arms around what that language actually means. And so I don't want you walking away thinking the commission didn't look at the legislative history that occurred back in that time frame. And I just want to share that with you.
Thank you. I appreciate that.
Thank you.
Thank you.
Good morning. My name is Sean Sullivan. I'm with the City Attorney's Office in Denver, and I want to thank you for your time today. I want to address a couple points that have already been made. In particular, question by Commissioner Leone and one by Commissioner Smith. And I don't think it's a straight home rule analysis where you've got a constitutional provision that says that home rule cities get to make it and you decide whether it's a matter of statewide concern, because I think your amendment addresses the issue specifically. And that's the question. You keep looking to Article 29 of the Constitution for your support. And the amendment says real clearly, the requirements of this article shall not apply to home rule counties or home rule municipalities that have adopted charters, ordinances, or resolutions that address the matters covered in this article. It doesn't say how to cover how those matters are addressed. It just says they must be addressed. And it takes that authority away from you. And that's in your chartering authority. So it's not a simple home rule analysis. It's both a home rule analysis to the extent that we have to be a home rule county or city, and it's a looking at the language of your charter amendment. The other thing that I'd like to address specifically is that Denver has had an ethics code for many, many years, and in 2001 adopted some amendments to it that established an independent ethics commission. That commission and our code predates the state constitutional amendment. During the discussion and leading up to the initiative and the campaign on that, Denver's code was addressed as an example of a code that addresses the same matters that were in the Constitution. So it would not apply, your authority or this Article 29 shall not apply to the city and county of Denver in that situation. We also prepared and we submitted with our comments a legal memorandum that we prepared at the time, immediately after the adoption of the constitutional amendment, that analyzed what the legal effects were for our officers and for our employees. And contemporaneously, before we got into this discussion, reached the same conclusion that we've reached, that we're advocating for today. So,
Thank you.
Thank you, and I just want to comment, I really appreciated your written comments that you did put in there. I guess one question I have is this assertion of that this code does not specifically apply to Denver. I've heard it, I've read it, I've seen it. We're not aware of that in the Blue Book analysis. Is there something more that we could look at in connection to that particular statement?
I'll see what I can do, but Common Cause was the drafter of that, and they made the same point in their comments.
Okay, thank you.
Good morning. Peg Pearl from Colorado Ethics Watch. We've submitted 2 different written comments that include our very specific legal interpretation and language that we think a position statement should use, so I'm not going to talk about that now. I know Commissioner Jones asked for that. We've submitted that in writing, so I don't want to take your time with that today. What I do want to point out is 2 things based on what's been discussed today, and especially for the benefit of the new Commissioner Sorensen, welcome, and newer commissioners who weren't here the whole time. Ethics Watch has been involved for the last 8 years of this commission in attending and cataloging things that have been going on, especially at times when the commission itself hasn't necessarily been keeping as good a records in terms of everything that's been going on in every single meeting. So what I do want to clarify as a factual and historical matter for the record is that this commission is not writing on a blank slate. It's not just that the home rule ethics issue hasn't come up. It's that this commission has had an affirmative policy in the other direction. And in fact, it still exists on your website right now in the frequently asked questions. It's been in your manuals. It's been given out by other executive directors. It's not in your rules of procedure or in a position statement, but here's what it says. Although the commission does have jurisdiction over many county and municipal employees, it does not have jurisdiction over home rule cities and counties which have its own ethics code and commission. This includes, for example, Denver and Colorado Springs and several others. If you have a question about if your city or county is home rule jurisdiction and has an ethics code, contact the commission. So to the extent you think you're writing on a blank slate and wonder why no one brought this up, what's happened is for many, many years, if someone called the commission with a possible complaint or an advisory opinion within a home rule ethics jurisdiction that had its own ethics code, they would be told informally by the executive director before things were even filed, we don't have jurisdiction over home rule stuff, go to your home rule entity. The Denver Board of Ethics had similar advice. If you look at trainings that have happened over the last 8 years with the Denver Board of Ethics or the IEC, or the Legislative Council, for example, over at the General Assembly, that has been the standard. So to the extent that there has been a statement of jurisdiction in the past, I realize it's not something like a regulation, but that's why maybe you haven't had a flood of advisory opinions over the last 8 years, because there was a general understanding of where those lanes were. And it's only been within the last year or two that those lanes have been questioned, because the issue did arise a couple years ago, as Commissioner Smith stated, with an advisory opinion that was then pulled, raising the question of, well, maybe a code isn't enough. Maybe it has to be a code of certain caliber to be able to adopt it. But before that, pretty much it was uniformly understood, I think, across the spectrum in the state that if you had a code, then you did your job. So I just wanted to make sure that everyone has that background here, that you are making a change in policy. And to that extent, the language I do suggest you have in whatever you adopt today, your position statement needs to have very clear information and language of the legal import of that document. So a position statement is something you made up in your rules as a legal document. It is unclear what sort of legal effect and binding effect it actually has on any of these cities or anyone watching online. The rules don't say, for example, whether or not such a statement is subject to judicial review. Your rules say that an advisory opinion and a letter ruling are explicitly not final agency action subject to judicial review, but it doesn't say anything either way about position statements. It also does not say, again, whether they're binding on their own, what sort of action someone has to take. Historically, other types of position statements, such as the position statement 1201 about travel, has basically been something on paper that people then use to guide how they write an advisory opinion to you. But that nothing happens without the advisory opinion. It has no self-enforcement, no legal import on its own. So I urge you, no matter what you decide substantively, and we do agree with the cities here that the draft goes too far, but whatever you decide, you need to be very clear in that document what the legal and binding effect is, so that people know their rights in terms of whether it goes in a court, if they come back to you, or what even it means. Otherwise, it's basically not worth the paper it's written on. And those would be my comments for today, in addition to everything we've submitted in writing. Thank you.
Okay, thanks, Peg. Okay.
Good morning and almost good afternoon. I'm Sam Mamet. I'm the Executive Director of the Colorado Municipal League. We're a statewide association of 269 cities and towns in the state, including all 101 home rule cities and towns. We appreciate your service on this commission.
Could you just restate your last name?
Sure, Mamet.
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 Thank you.
Former Senator Bacon and former Representative Smith are well acquainted with me. We appreciate your service on this commission. Mr. Chairman, I think you stated it very well earlier. You have a constitutional charge, which the voters of this good state have given you, each of you, to assure that there is ethical behavior, as the amendment spells it out, for our public officials in Colorado. It's a very serious charge, and one that you take very seriously, and we appreciate that. I'm not going to get into the legal debate. You've heard much on that, and we've submitted our own comments as to whether or not you have jurisdiction to go in this direction. I'll defer to others. That's already been clearly articulated. We don't believe that you have, but that'll be the courts ultimately to make that decision, I suppose. Let's focus on this from a practical standpoint and look at the universe of the 101 home rule cities and towns in the state and the 2 home rule counties in the state. and focus on that for a moment. You develop a position statement, a set of protocols and procedures suggested to home rule cities and towns that they must follow. Fine. I would submit at that point you have got yourselves a tiger by the tail, because in order to enforce this properly, or to properly hear complaints or other kinds of points that members of the public may have, you're then going to be tasked with, each time something like that arises, to take a look at an individual charter, an individual home rule city or town's own policies or procedures, as well as the 2 home rule counties, and basically ascertain, well, does it meet entirely with the standards we've adopted? Does it meet partially with the standards we've adopted? Or does it not meet at all the standards we've adopted? I'd submit there's an easier process to follow here that will alleviate a great deal of brain damage that I see headed your way. And as Commissioner Bacon and Commissioner Smith know from their days in the legislature and working with us and many others, let's look at practical solutions to an issue that's been presented. And I'd submit a more practical solution to approach this is to work with the Colorado Municipal League and Colorado counties and have workshops throughout the state to provide training and technical assistance on the role of the commission, on the background towards ethics, best practices in ethics at the local level. We have many examples of that already by Colorado Ethics Watch own survey. There's over 60 of the 101 home rule cities and towns in the state that have already adopted a variety of forms of provisions dealing with ethics. Now, they may not comport in every way with the criteria you're looking at today, but they acknowledge that this is something that needs to be addressed. And Ms. Massey did an excellent job of explaining one particular city's experience, but we have many other examples of that as well. So it isn't that at the municipal level or the county level. By the way, I find many problems with this amendment, one of which is why it doesn't cover special districts and school districts. But that's another story altogether. Having said that and gotten that out of my system, the point is this. We don't need to be told at the county and municipal level that having appropriate criteria, policies, and procedures that govern ethics and all of the things around that is not important. Of course it's important. The discussion ought to be the right way to proceed here. This is not the right way because it's going to result in litigation and tension, and I've got a lot of home rule cities and towns already that are pretty dyspeptic over the whole thing here, and are not real happy with the Independent Ethics Commission right now. That's their prerogative. What I'm suggesting is a different approach. Let's work together and do some joint training. We have done that in the past with the commission, and would be certainly willing to do that in the future. Last point that I want to make. Commissioner Smith cited Title 24, which is the Code of Ethics, Standards of Conduct for Public Officials. And even in the legislative declaration, it acknowledges this conundrum that some of you are expressing today. In the last sentence, and this is the legislature's declaration, this is a statement of their interpretation of Code of Ethics and Standards of Conduct. The provisions of this Part 1 recognize that some actions are conflicts per se between public duty and private interest, while other actions may or may not pose such conflicts depending on the surrounding circumstances. And if you take that philosophy, that declaration, and apply it to the task ahead, you're going to be challenged each and every time some complaint has been filed by an individual against a particular home rule city's or county provisions, and you're going to have to put those up against the standards that you've adopted and ascertain, well, is it a conflict or is it not? Because we have to also look at the totality of the circumstances that affect all of this from the beginning. I think you're heading down a very perilous path here, and I'm suggesting an easier way to approach this so we can reach some agreement on this. I do not want to see us in disagreement or in conflict with the commission, and I fear that that's the path we're heading down, and I don't like what I see. And I just state that with the greatest of respect, and I thank you very much for your service to the state, because what you're doing is extremely important. The citizens have said so by virtue of this constitutional amendment, and we thank you for that. If there's some questions, I'll be glad to answer them.
So how is your proposal of workshops and training throughout the state, how does that address our conundrum?
Well, that's a great question, Commissioner. Isn't the intent of this to put forward the notion of good ethical behavior as a matter of your individual capacity as an elected official? Doesn't that make sense? No, it doesn't make sense?
Sure, of course, we can all agree, sure, that's our duty.
Right.
That's not helping me, though. Yes, that's our duty. It's our duty to put forth that people have an understanding of their ethical duties.
Right.
How does that help me with my conundrum?
And your conundrum is?
With respect to the language that we're all here talking
Right.
about, how do we address the issues that we're not agreeing on? And you're saying if we have workshops and training, that'll take care of it.
I think, Commissioner, the way that you address the conundrum that you all find yourselves in today, and the conundrum we will find ourselves should this position statement be adopted, is moving forward. What does it mean, and how do we behave, and how do we practice good ethical behavior? And I guess the only way we're going to practice good ethical behavior under the circumstances is to litigate it until we get some answers from the courts as to what exactly it means. I'm perhaps putting forward a different approach. I don't want to go down that path. I want to go down a path that's a little harder and a little more difficult. We have 1,800 men and women who serve as elected officials in our cities and towns across the state. I think each one of them would welcome a colloquy and a dialogue with the commission and others on good ethical behavior, and what's good and what's not, and best practices that people can borrow from individual communities. That's what I'm putting forward here. That's what we do best as an organization: train and help inform our elected leaders.
Thank you.
Commissioner Bacon?
Sam, one quick question.
Yes.
And this is all a real learning opportunity for me in this whole process. And
It certainly has been for me this morning.
Legislative experience, but when complaints, much of our business is complaint driven.
Right.
And so what if we were to receive a complaint that in investigation and even before we investigate, there is obviously a violation of the spirit of Amendment 29, and it is a home rule entity, and they do not have an ethics policy that even could pass what I consider a smell test.
Mm-hmm.
Do we say, well, we need to incorporate that entity, that home rule city, in a workshop in order to try to get them to create a more robust ethics policy and then dismiss the complaint because of lack of jurisdiction?
Mm-hmm.
So this is what you're suggesting that I must do.
I'm not suggesting that you must do anything,
Thank you,
because
Sam.
that's the commission's prerogative. But I think at the end of the day, is there a practical, I'm going to answer it in two ways. Is there a general need to always inform local elected officials of appropriate ethical behavior? Yes. Secondly, is there a practical need in Colorado to adopt these standards or any other criteria as it relates to home rule cities and towns? And the answer, in my judgment, is unequivocally no. If you look at the data and the statistics developed by the Colorado Ethics Watch Group, they've demonstrated very clearly the vast majority of home rule charters in this state cover aspects of this. You'll have to decide whether you want to be put in the position as a member of this commission to pick and choose every time a complaint comes up. Well, yeah, I guess the charter meets 80% of our standards, or no, it only meets 50% of the standards. And where's the fine line? That's the lane you're going to wind up driving in, and I don't envy your position, because you're going to have to pick and choose, and that's going to be very difficult. And
that's
I
the
think,
tiger by the tail you were referring to? That's the tiger by the tail you were referring to earlier.
Absolutely it is, absolutely.
Yeah, I feel like we're reliving the same regulatory debate that I've seen for 35 years. It's always the people that don't need regulation that are the most opposed to it. It's like we're preaching to the choir. I mean, what really is driving this from the commission standpoint is not so much, it's not a complaint about Colorado Springs, and it's not a complaint about Boulder. It's a complaint from other, there are complaints about other home rule cities and counties out there that will make your hair curl. And the argument we're hearing is, that's just too bad, because you don't have any jurisdiction over home rule cities. And so, I think one of the things, if I have anything to say to the Winetta and City and County Boulder, is I don't think that what we're talking about in a position statement here is going to affect very much what you're doing. But there are places out there that are sadly, that are just, in my view, kind of thumbing their nose at the whole concept of ethics, and have come up with their own way of doing things that don't even come close to addressing these issues. And it's so easy. You see it. You see this erosion. You see this erosion. Without standards, there's an erosion, and it creates the cynicism that leads to bad reactions. And part of what we're trying to do here is, despite all the ethics codes and despite all the efforts of the Municipal League and all the efforts of Colorado counties, prior to the adoption of this amendment, the voters saw a problem, and they reacted with this amendment that's created all kinds of difficulties that we try and deal with. And that's part of why we're trying to have our own review of this amendment. But if you take the position that it doesn't apply at all, and you just swallow these exceptions, then it's going to lead to even worse policy than what we have right now, I think.
Well, I want to be respectful of the time you have left here. Very briefly this, Mr. Chairman. You're very articulate in your viewpoint, and I respect that. However, I can't tell you what the voters intended. I have no idea what's in the minds of the voters. I can simply tell you what the words in the Constitution say. And if the proponents of Amendment 41, as it was called, intended this to expressly and explicitly cover home rule cities, towns, and counties, the amendment would have said so. We have other examples of that. There's a little amendment in Article 10 called Tabor, adopted in 1992. It very clearly and very expressly covers all local governments, including home rule municipalities and counties. And if the proponents intended Amendment 41 to do the same thing, they could have done that. They didn't. They bifurcated the language in the section of the amendment that's already been alluded to. And
But can't we play the same game? If the amendment, if the voters had intended that this not apply to home rule cities, why wouldn't the amendment say the requirements of this article should not apply to home rule counties or home rule municipalities, period?
Well, I'm not going to argue the case before the Court of Appeals here this morning. Let's just say that will be a constitutional interpretation that the courts will make at some point, and they will. Thank you.
Thanks.
Mr. Chairman, before you leave.
Yes.
Let me note for the record that the commission very much appreciates the work of CML. Sam has mentioned the training. Historically, CML has not only hosted a summer convention and helped with some public outreach. I just, for purposes of new commissioner, knowing, want to thank you for that. Also want to thank you for the input you, previously Mr. Wilson, have put into
Right.
this. One other thing, and I don't know how to do this, but I don't want to be talking past each other, but I think in some ways it needs to be stated for the record that due to our own purposes and following other constitutional requirements, the commission is not in a position we can share with the public all of the concerns that are here. So what I hear some of the commissioners expressing in frustration, don't let that go past you. We may, by our own practices, procedures, and following our Constitution, may be restricted in all of the public disclosures that we make, okay?
Right.
But Sam, it's great to see you.
It's great to see you,
Appreciate
Matt.
your comments. And I think the chair has covered the concern on trying to interpret the Constitution, so.
Thank you for your work. Thank you.
Thank you.
Thank you.
Anyone else?
Good morning, everybody.
morning.
Michael Hyman, City Attorney for the City of Aurora. I actually think I have nothing really more to add than what has been said today. I thank each of my colleagues, Sam Mamet from the Municipal League, and all of the city attorneys that come here to express the viewpoint that I think we all share in the home rule community. And I thank Kate Pearl back there for Colorado Ethics Watch for pointing out a number of things that I think needed to be said. Essentially, I appreciate the job that you all have to do. I appreciate the need for ethics in government. But what I think the voters of the state said and saw when they saw the question on the ballot 10 years ago, and when they saw the language of the Constitution, is the fact that we need local control. We have had a history of local control in this state. We've had a history of our local legislative bodies making these decisions and being responsible to their communities. Frankly, I have not much to add. The fact that I believe 62 of our cities have done so, including Aurora, Colorado Springs, Centennial, Boulder, Denver, who are all represented here today. So I would ask you to carefully consider what you say in your position statement, and the fact that you have not only a number of home rule cities and counties who've commented, but also Colorado Ethics Watch and the authors of the amendment, Colorado Common Cause, saying this is not what was intended by the voters. So I thank you for your time. I know we've been doing this for the past 11 or so months, and I don't think I have much to add that you haven't already heard from me, so.
Okay.
Thank
And by the way, specifically, Mike, with respect to you, we do appreciate the approach that the city has taken. I think you were part of the initial request to us for guidance about Aurora City Councilwoman, and we appreciate the approach of, coming to us and raising the issue. And in some ways, you've been held, your issue has been held hostage, so to speak, to this lengthy deliberation we've had, but I can't be more clear in expressing to you our gratitude. So even if we disagree or agree at the end of the day, we do appreciate the dialogue that we've had with you and the input that you've given us.
Great. Thank you.
Thank you.
Mr. Chairman, just one comment, and this goes because Mr. Sullivan came here. No, you're finished. I just want to thank, in the early days of this commission, Mr. Henry. I think it's the first time we've ever had anybody from Denver here, and I just want to express that Michael Henry is quite an asset for all of you through those years, and he certainly did dialogue and talk to the commission through the last few years. We appreciate that. Okay.
Okay, we are a little bit time constrained. Mr. Ioannidis advises me that the court has told us we need to be out of this courtroom, but not necessarily right at high noon. So I think we have maybe 15 minutes that we could probably still spend on this topic. Let me first see if there's a motion to approve the position statement as written, and if we can get that motion on the table, then we can see if we can't tackle a few amendments yet this afternoon, if that's consistent with the pleasure of the commission.
And that's with the understanding that we'll be working from there.
Yes, working from there.
Okay.
And I suppose working on this is going to go over several days, maybe even weeks. But in order to get the ball rolling, I move approval of the draft position statement on ethics as they apply to home rule cities, counties.
Mr. Chairman, I'll second that for the purpose of moving forward so we can build that foundation.
Okay, there's been a motion and a second to approve the draft position statement respecting home rule cities. So we're in the period of discussion and possible amendments. Commissioner Smith, do you have any amendments that you'd like to offer?
I do, Mr. Chairman, and I'll ask you for guidance. Do you want me, would you prefer to take these up kind of one by one, or?
I think it would be nice if we could, if there are a couple of simple ones that we can take separately and
Okay.
kind of get the process down. And then if there's an amendment that's dependent on another amendment for it to make sense, then we can take them up together. But if you have one that's sort of standalone, why don't we start with that?
I would, and Mr. Chairman, I would move the inclusion of just the general context, or the comment on the authority of home rule municipalities and home rule counties. I don't care if that's a footnote, and I intend to entirely turn that over to Dino, but I just, in reviewing that, I thought we were a little remiss in leaving that out, and I'd just like to see that, so.
Okay, does everyone have Commissioner Smith's written comments in front of them? Okay, so I'm gonna, as we do this, just to keep a record that we'll have Mr. Ioannidis keep as part of our record here of what we've done. I'm gonna take, we're gonna number these paragraphs as we go through them. So I assume that you're referring to the language under comments from
Yes.
Commissioner Smith on position statement.
Right.
And you have 3 lines that start with add a general comment to the text.
Yeah, and,
All right, so those 3 lines, I'm gonna number that as amendment number 1, okay? Is that all right? Is that clear to everyone what I'm doing? Okay, so you're moving amendment number 1 to add a general comment to the text or footnote that home rule cities derive their authority from Article 20, Section 6 of the Colorado Constitution, and home rule counties derive their authority from the Colorado statutes, Section 30-35-103. Okay, is there a second to that amendment?
Second.
It's been moved and seconded that the draft position statement be amended in that fashion. Is there any more discussion about that amendment? Hearing none, let's take a vote. And we won't do formal roll call, but I'll ask all those in favor of the amendment, say aye.
Aye.
And any opposed? There are none. Okay, so that amendment passes. Okay. Further amendments?
Mr. Chairman, I'm trying to, and I could try and take probably less conflicting stuff, but I really think at the heart of this, the next item I'd take up, it's the second numeral 2 on there dealing with the gift ban. This is the concept of the bright line test. Again, for members of the public that are here today, the $59 mark becomes the presumption, as the chair has talked about. It does provide exceptions that are both in Article 29, those that have been developed by the commission. In addition to that, the ability of home rule cities and counties to actually to adopt additional exceptions as long as they demonstrate a reasonable nexus to how the gift amount will preserve ethical behavior. Mr. Chairman, I just think it's appropriate to start there. If I'm wrong, I'll withdraw that motion, or for the amendment.
Okay, so let me see if I can craft that.
Just very for clarity only, Commissioner Smith referred to number 2 in his written document.
No.
2 of those.
I understand.
Okay,
Yeah.
thank you.
All right, so let me see if I can frame that into an amendment
Yes,
and see if it's acceptable to you. So we're talking about the second number 2 in your
Yes.
draft.
at which I've turned over a new draft, and Nate made it new number 3 to Dino, so.
Okay, but it's the language at the bottom of the first page that begins with a gift ban prohibiting local officials and local government employees.
And in the last statement, instead of saying promote, it would say preserve ethical behavior, or whatever you want to do. I'm giving you some latitude, Mr. Chairman. It's that concept. If you want to restate that or do something along those lines, that's the subject matter.
So you would propose then that the bolded portion of your amendment here repeats what's in the draft position statement?
It does,
And
and
then-
adding some additional comments to clarify that
All right, so that bolded language,
is already there.
All right, so I've marked as amendment number 2, everything from where you say a gift ban prohibiting local officials in bold down to the end of that paragraph,
Yep.
okay?
The top of the next page.
The top of the next
Yeah.
page, okay, so that would be amendment number 2. Is everybody with me?
Mr. Chair and Commissioner Smith, I wonder if, rather than above, you could say different than, to allow for lowering it.
I am fine. In fact, I'm just trying to mainly get the concept of a gift ban as a bright line test. I have really no objection to something similar to what the chair stated earlier in the hearing, trying to define this. I'm very open. It's just, you're either with this concept of having a gift ban, and that gift ban actually amounts to some kind of a dollar figure acknowledgement that is there.
And
All
so,
right.
and so the intent here, Commissioner Smith, is that even though we have mentioned the $59,
Right.
we are saying in effect that the ordinance or whatever is adopted by the city or county may be different than that if they demonstrate a reasonable nexus to the difference in the gift ban.
That is correct for home rule cities and counties, yes.
And so what we're doing here is, we're saying this is what the Constitution gives to everybody else. But if you want to have something different than, you're welcome to do it, but to justify it.
Yes,
Is that right?
yes.
And is that clear as it's written? So what we're doing is having it both ways. We're not having a hard figure of $59, and this may get to Commissioner Jones' issue, and I think probably reasonably so. But this is what is suggested, and so deal with it somehow to justify it.
Yeah, and so let me see if I can just add
Absolutely.
just a couple of words to that and see if that's, before we get the amendment, before we move the amendment
Okay.
and discuss it and vote on it. Just to put it in the framework, so you're, again, this is an amendment to the pending position statement, so that, just for those who may or not be following along, this is the part of the position statement that's listing the things that are sort of essential elements of a home rule city ethics code.
Yes,
And so your amendment would preserve the idea that a gift ban is an essential element,
yes,
but your language would soften the $59 limit. Is that
correct.
in summary? Okay, so I would suggest you maybe offer to you to see if you're willing to accept this revision before we move the amendment. In the second paragraph where you say the commission did not choose the gift ban amount, if you just bear with me for a minute, I would remove that, I would delete that.
Okay,
And I would say, I would start that paragraph by saying, for a home rule entity, there is a presumption that the $59 amount is acceptable, period. However, if a home rule, and then we'll take up your language, if a home rule entity were to pursue a gift ban amount, and I think I would leave in above the constitutional limit,
Okay,
because if it's below the constitutional limit, we already have the provision in the Constitution that says
and I
you can
think,
have a stricter,
yeah,
okay?
Yeah.
and I think we need to say constitutional limit rather than $59 too, because it moves.
Above the constitutional limit, okay.
Yeah,
Then it will, and I would, instead of saying need to demonstrate, I would say bear the burden of demonstrating,
okay,
because at least that's, bear the burden of demonstrating is kind of a burden of proof concept. I think it will have legal meaning to a court. Bear the burden of demonstrating a reasonable nexus to demonstrate how such gift amount will promote ethical behavior.
Preserve.
yeah, to preserve.
To preserve, preserve, not promote, okay. All right,
So then, for the first sentence, it's now for a home rule entity, there is a presumption that the constitutional limit is acceptable. However, if a home rule entity were to pursue a gift ban amount above the constitutional limit, the home rule entity will bear the burden of demonstrating a reasonable nexus to demonstrate how such gift will preserve ethical behavior.
that's right. Is that drafting acceptable to you? Okay, does everybody follow along with that? Okay.
Yeah, I follow along with it, but help me with some language, but if the entity is going to have this dinner for the law enforcement, and so promote or preserving ethical behavior, if we might include something about serving the purposes of the greater good of the community, or whatever this is. I'm trying to get to, sometimes decisions are made in order to include people that might be construed as the gift, but then it is for the greater good of whatever we're doing as a municipality, a county, in order to honor and to promote good government.
And
think-
that's the purpose of my next
Then if you, at the
sentence.
top of the next page, do you see the language that's part of his amendment?
Yeah, I concur. It's just, I think we've already responded to that is an exception and there is room for additional exceptions.
Yes, but promoting ethical behavior is more restrictive than what I'm trying to get at here.
I
Okay.
think what Commissioner Bacon is saying, that I agree with it, almost the way you just said it, that it's not, I mean, preserving ethical behavior, okay, and the community and how it serves the community and good governance for that particular municipality or locality.
That's right, how it enhances good governance of that community.
Because I think that's important, and that's the whole point of the exception for municipalities and them having their own flavor, and respecting that, so.
And there's a bit of a precedent that, and for the legislators, whenever legislators are invited to these sorts of events, that if they are participants in it, and sometimes this has a greater or a lesser kind of participation, but those opportunities are really beneficial for people to get together in order to celebrate, to work together, and do many other sorts of things. And I'd like for this to reflect that we don't want to discourage those ways in which we can get people to collaborate and cooperate in order to carry on the business of good government.
And Commissioner Bacon, I understand what you're getting to. The example of the legislators is going to directly pull those legislators under the Article 29, if you were bringing legislators over.
No, I'm just
Yeah.
recounting my experience with the legislature.
Okay,
And so
okay.
I'm transferring that same sort of benefit to municipalities, counties that do certain things. If it's a dinner, honoring the law enforcement and even learning about something, then it may be construed that this meal violates the $59, but still we are having these events in order to promote good government.
Okay. I'm a little concerned that in creating the exceptions, that we start throwing other language that doesn't address ethics, and I don't really want to go there. I really want to tie this to an ethical standard. I hear what you're saying. I am certainly open to the fact that this language may not get you where you want to be, but I think the exception has got to either fall within an exception under Article 29 or something that goes one step further and shows how ethics would be preserved in that circumstance. I'm not opposed to trying to do something that incorporates the example that was given, just a little worried about using the word community, and now all of a sudden that takes on a meaning in and of itself. I'd rather work towards something that probably held ethics as the key component, but I'm really scared to go beyond that standard.
Is it? Go ahead, I'm sorry.
Yeah.
But the constitutional amendment specifically speaks of ethics and the local government issue. I don't know that they need to be separated. I get the
Yeah.
point of where ethics commission goes when we talk about the ethical issues, but the Constitution talks about both. And that's why I think the language that Commissioner Bacon is trying to suggest recognizes what our charge is, specifically, which includes the uniqueness of the home rule municipality and locality.
Maybe we
Well-
can take this on as a project, on a continuing conversation as we move forward in trying to craft language.
Let me take one stab at this, and then
Okay.
maybe we can at least get this one put to bed. I think the concept that you're trying to get at with this last sentence is basically to incorporate somehow by reference all of the decisions that we have made over the last 8 years, recognizing exceptions and limitations and interpretations of Article 29. So to address Commissioner Jones' point, this is not reversing or modifying or altering any of that. All of the flexibility
Right.
that we've built into this amendment through our jurisprudence is preserved. Home rule cities aren't going to be held to a stricter standard than that, obviously. So that's one category. I suppose a second category is, I don't pretend to think that we've resolved every issue that could arise under the amendment.
Right.
And so there's probably going to be occasions where home rule cities, independent commissions, are confronted with new, fresh issues that have never been ruled on here at the commission, and sort of are charting their own path with respect to those exceptions. I think that, to me, the only important concept here is that, and I know this will rub the home rule cities the wrong way, but there is a concept here, in my view of the world, in this amendment, of supremacy. And when we rule on something and say, our interpretation of Amendment 29 is this, that this is allowed, this is okay, that's not, that the commissions of the cities need to track that, and can't say, well, sorry, we just disagree, with that. So we need to embrace the flexibility that we've built into our own jurisprudence without undermining the whole concept of having minimum standards by saying, well, if it's a matter of, good government, then you can do what you want. I'm not quite, the only way I could get to that language would be to say, the gift ban may include the exceptions included in Article 29, together with exceptions recognized by the commission, and similar exceptions which demonstrate a reasonable nexus to how such gift amount will preserve or promote ethical behavior.
And
That way you incorporate
Yeah.
all of what we've done plus what is yet to be done.
And I think for purposes today of moving forward and getting some language, I'm suggesting that as a concept. I want you to read it and make sure that it does that. But it still allows, in my view, home rule cities and counties to take up those matters that may be unique to those entities. And as long as they chart out those courses, the truth is, that's really all we're trying to suggest, is the exception has an ethical basis.
And
in
I
it.
think the chair, by pointing out that the cities here, or you name cities that are not the issue, there's the other cities that aren't having ethical, or addressing the ethical issues that we're talking about. I think, I just want the language to also, I need the language to recognize that there are cities who have good ethical positions and who've examined this and they've made them unique to themselves. I need to feel like we're not punishing them in order to get at the balance of the localities. So as long as the language contemplates that, I'd be okay.
So the suggestion I have for language would be this: the gift ban may include the exceptions included in Article 29, together with exceptions recognized by the IEC, together with similar exceptions adopted by the home rule entities which demonstrate a reasonable nexus to demonstrate how such gift amount will promote ethical behavior. Or do you want to say preserve instead of promote?
And I have another alternative, rather than,
Okay.
and then on the how such a gift will not violate ethical behavior. And so promotion of ethical behavior
Yeah.
does some mental gymnastics.
And
but
I
if
don't
they-
like promote either. I think preserve is what I'm looking for, but
Yeah,
I'm
but-
looking for
But
some.
even preserve, I'm trying to say, this doesn't violate ethical behavior when you do these sorts of things.
So you would replace demonstrate a reasonable nexus to demonstrate how such gift amount will promote. You would
Will
replace,
not violate
you would replace that with will not violate
ethical behavior.
ethical standards?
Sure.
You
Yeah,
like behavior or standards? I'm not dogmatic. Behavior's okay for me, all right.
either one.
I had a concern that, can you read it again?
The gift ban may include the exceptions included in Article 29, together with exceptions recognized by the IEC, together with similar exceptions adopted by home rule entities, which will not violate ethical behavior.
My concern with similar suggests that we considered everything, and if it's gotta be similar. I mean, if we're barely addressing this issue for the first time, I doubt that similar covers everything that might come up. So I think that narrows it too much. I don't even know what similar means. I'd have to read everything we've done to see if, okay, that's similar.
How about not inconsistent with? I mean, the concept I'm trying to get at is you can develop your own jurisprudence as long as does not conflict with
But we have,
the state constitution as we interpret it. It's kind of like when district courts are given the authority to make decisions that are, district courts adopt rulings on matters of first impression all the time, and the only constraint on them is if they can't do something that's flatly inconsistent with what the Court of Appeals or the Supreme Court has done, but they can chart their own way on matters of first impression, and, you know, if somebody's unhappy about it, they complain to us and say, hey, that city is off the rails. They're completely off the rails. They're doing something so incompatible with the amendment and jurisprudence that's developed around it that it's not addressing the matters set forth in Article 29. And you know, most of the time, we would probably defer to the home rule city. Other times, we might say, yeah, that's right, they're off the rails.
I guess I'm not, the language itself, to me, leaves exposure to the breadth of what we've done that may or may not affect home rule cities and counties. I mean, I don't know that everything that we've already said and done directly affects home rule cities and counties. Because if we have not been evaluating home rule cities and counties in our analysis, I just don't have enough historical knowledge to be able to say, oh yeah, that'll take care of it.
And to your point, a whole lot of what we've done, more of what we've done has involved state employees and public officials. I'm wondering if we can kind of wrap this up to a point where we can get a concept down. I know even the word promote, this morning I like the word preserve better than that, but get to a point where we can at least, you know,
But
I mean,
what I'm trying to do, Matt, is to get those exceptions, which even though ethical behavior is not a part of the dinner with the law enforcement,
right.
having that does not violate ethical behavior and standards.
Even if it was $100?
Yes. If a city council is having a dinner to honor the law enforcement, and that is a $100 dinner, all well and good, because you're doing something that's for the good of the entity, and it's not violating an ethical standard in that community.
Okay.
Commissioner Sorensen, do you have any input?
I appreciate the language about does not violate. I think acknowledging that. Promote is pretty general.
And you have to prove that it promotes ethical behavior rather than it does not do anything to detract from ethical behavior.
And that's a broader standard. And I'm okay with that, if that's the
I'm okay with the will
standard.
not violate as well.
Yeah,
But I'm okay with, I was okay, the amendment that we were working on that with Matt's language, and then the addition of Commissioner Bacon's language. I think I'm getting bogged down again with the chair's language, and I'm not sure that the chair's language incorporates Commissioner Bacon's language sufficiently. So that's, I feel like I'm rolling backwards from the place of being able to say we can reach an agreement here.
okay.
And Commissioner Sorensen, where are you on that?
And so I'm trying to, is it the similar concept? Is that the
It's
piece that you're rolling back to?
The quantifiers that are going into the current language, I've already articulated how I think they how it's referencing what we've done in the past and how I have concerns about that. So if we remove the quantifiers, go back to the sentence, if a home rule entity were to pursue a gift, ban amount above the constitutional, if a home rule entity were to pursue a gift ban amount above the constitutional limit, it will be the burden of the home rule entity to demonstrate a reasonable nexus, to demonstrate how such gift will preserve ethical behavior, and
then the next sentence,
which is, and
at the top of the next page.
the gift preserve ethical behavior, period. The gift ban may include exceptions included in Article 29, together with exceptions which demonstrate a reasonable nexus to demonstrate how such gift amount will promote ethical behavior, which we've changed to preserve ethical behavior, which we've changed to not violate ethical behavior.
Okay.
Standards.
Standards.
We have to
And we changed the standards.
Okay, all right.
So that, are you okay with,
Yeah.
is that your understanding?
And, we're going to have another opportunity maybe to wordsmith it, but I think this is good for right now. And we
Right, I
can-
mean, if Dina could put that in a sentence and then we could circulate it, that'd be nice.
That's right.
Okay, all
A
right.
new draft.
A new draft.
All right, so we're out of time in this room, so let's wrap it up this way and give
What
Dino
is our
some.
time?
Well, we should have been out of here.
Okay.
At a minimum.
Yeah.
So let me, and please, raise your hand if you object to this. I think I'm capturing what everybody's sentiments here. So Dino, what we need, and I guess we have another meeting on Monday. We're gonna take this up again on Monday. If it's not in the agenda notice, get it in the agenda notice, because we're gonna try and get something done on this so we can take up our business. I think we are basically down to the last sentence of Matt's amendment number 2 here. And we would like you to do is redraft that last sentence. And,
Or redraft the sentence that we're trying to be in agreement on, the entire first and second, that entire,
well, I thought that we had revised the last sentence at the bottom of page 1 to where everybody was okay with it, and then we were just going back and forth about what the last sentence would say to incorporate the concept of flexibility.
right, but if Dino's sentence could incorporate not just the last sentence, but the sentence that we look like we might be in agreement on, can that also be?
Yeah,
Great. That's
yeah.
what I meant.
Yeah, he'll make those changes. Those we agreed on for the most part. The last sentence, though, we've been kind of going back and forth about whether we want to say preserve or promote. I think we ended up coalescing around take out demonstrate a reasonable nexus to demonstrate how such gift amount will promote. And we've replaced that with will not violate. And we've changed into will not violate ethical behavior. And I don't know whether we had coalescence around the idea that we would say the gift ban may include the exceptions included in Article 29, together with exceptions recognized by the IEC, together with other exceptions adopted by home rule entities that do not, that's where I stopped, that do not violate ethical behavior was the way.
The way Bob had it, and I'm okay with that.
Okay, do you have that? Try and draft it that way, and then we'll look at it Monday, and if people say, oh, wait a minute, that's not what I thought
And
we
do
were
we
doing.
definitely remove demonstrate a reasonable nexus?
Let's draft it that way, and then when we come back Monday, if somebody wants to put that back in, they can.
And-
All right,
and
so,
just for discussion purposes, because you're focused on this language, please take a quick look at the other number 2 above that. Bob, you might want to move those same concepts. April, you might want to move those same concepts up there.
Okay.
It's just for thought process.
Okay, sounds
good.
good.
okay, and just sort of to cap it off, where we are framework-wise right now is we have a motion pending to approve the draft position statement as written. We've made one amendment to it. We're considering the second amendment. We'll vote on that Monday, and then we'll continue to look at additional amendments as offered by Commissioner Smith. But right now, it looks like those amendments are, for the most part, going down those items that specify what's required of a home rule city or county ethics charter and tweaking them one way or another.
Yes.
Okay. All right.
Mr. Chairman, would you like a draft as, an entire draft with all the amendments as it currently stands for sort of fresh eyes on Monday? I assume that's what you'd like.
Well, with the amendments we've discussed, but I think this is as efficient as we can be in this process. I think we would be more inefficient if you drafted something that incorporated all of Commissioner Smith's amendments.
Yeah, I meant the first thing you said.
Yes, okay, yeah, let's continue to do this. Give us a draft of what we have so far, and then we'll continue to do this on Monday. All right, is there a motion to adjourn?
So moved.
Second?
Moved and seconded that we adjourn the meeting. Is all those in favor say aye?
Aye.
Aye. Any opposed? There are none. We're adjourned.
But we have not voted on the amendment.